line, highlighters, pages, and a fearless mind. She walked that hall with fire in her chest, law school dreams and a future dressed. She laughed too loud, she stayed too late, left her name in every room she made. Then one hard night the door went still, and grief has been calling the hill. 25 years and the candles burn, questions circle with no return. They named a man and closed the file, but something in the shadows stayed a while. Will the truth come out? Will the truth come out? Who was close enough to leave that down? Will the truth come out? Will the truth come out? 25 years on, we're still calling out. Edric stood under borrowed blame, a headline pinned to a living name, but paper folds and stories bend, and the wrong road can still pretend there's someone nearer in the smoke, a familiar face, a half-spoken joke, a door left open, a lie held tight, a hand that knew her on that night. 25 years and the candles burn, questions circle with no return. They named a man and closed the file, but something in the shadows stayed a while. Will the truth come out? Will the truth come out? Who was close enough to leave that down? Will the truth come out? Will the truth come out? 25 years on, we're still calling out. Her books still wait in the dark for one clean name, one honest mark. If guilt was hidden in plain sight, then let it break. Find morning light. One closer look, one final thread, one spoken truth for the dead. Let the silence lose its crown. Let the truth come out now. Will the truth come out? Will the truth come out? Who was close enough to leave that down? Will the truth come out? Will the truth come out? 25 years on, we're still calling out. Will the truth come out? Will the truth come out? Tara, we're still here till the truth comes out.
Good morning, everybody. It is Monday. Monday. I'm Angie. Thank you for coming. Hello to all the Facebook people. Excuse me. My goodness. So couple before I do that. Please like, share, and subscribe. Donations are never required, but always appreciated. I have Cash App, $NGM1984YT, Venmo at NGM1984, Buy Me a Coffee, NGM1984. You can follow me on X at NGM1984YT or on Facebook at Angie Mead. If you have any cases you would like us to follow after we are done with this one, please email me at ngm1984yt@gmail.com, or you can also use that email to ask for the link to join the Discord. So, couple updates on other cases that we are following. Today, there was an emergency hearing regarding Michael Proctor because he was supposed to go for his deposition today. As of right now, it has been postponed or stayed for 24 hours. And they are supposed to go back at 4:15 Eastern for another hearing because Judge Gilday allowed Proctor's attorneys to supplement their papers that were filed over the weekend as to why Michael Proctor could not appear for his deposition today. My God. Anyway, in the Ham case, this is Higgins, Albert McCabe versus Karen and Aiden. They have filed a amended complaint, and thank you to Kelly Steffi on X. Please go give her a follow. And she gives a pretty decent summary of what it includes. It says Jennifer McCabe, Brian Albert, Colin Albert, and Brian Higgins have now filed a first amended complaint against Karen Reed and Aiden Carney in Plymouth Superior Court. The opening paragraphs are striking in both scope and language. The plaintiffs allege that Reed and Carney engaged in a multi-year conspiracy designed to interfere with the criminal justice process in Norfolk County. They claim they sought to protect and enrich themselves by allegedly defaming, harassing, and retaliating. Hang on one second. Yes. Against witnesses in the John O'Keefe case. The amended complaint further states that Karen Reed and Aiden Carney falsely accused the plaintiffs of being responsible for John O'Keefe's death. If he wasn't hit by a car, which the evidence shows, science proves that he was not hit by a car, then who did it? If it wasn't Karen and it wasn't them, who the hell did it? That's my question. They claim the defendants carried out a calculated campaign that caused a daily tidal wave of hatred, harassment, and intimidation. Really? The filing characterizes the actions of Reed and Carney as an effort to assassinate the character and reputations of the four plaintiffs. What character and what reputation? They're a bunch of thugs, my opinion. This amended complaint appears to double down on the central theme of the Ham lawsuit that Karen and Turtle Boy orchestrated a coordinated effort that damaged the plaintiffs' reputations and subjected them to harassment. Notably, these are the same individuals, and these same individuals are also defendants in Karen Reed's federal civil rights lawsuit against the Massachusetts State Police. Stop. Give me a hug and go. Go take a nap. You were told to go take a nap, so go take a nap. Sorry, y'all. Life of being a mommy. Hurry up, Aria. Outside. Go. Now. Sorry. Notably, these same individuals are also defendants in Karen Reed's civil lawsuit against the Massachusetts State Police and others. Correction, the federal lawsuit is not against the Massachusetts State Police. It is against the House defendants as well as Tully, Buchanan, and Proctor in their own individual capacities, meaning discovery in various civil cases could become increasingly intertwined. This is true. As always, allegations contained in a complaint are claims made by one side and are not findings. The defendants will have the opportunity to respond, and the court will ultimately decide what evidence supports which claims. The battle between the parties is clearly escalating, and this amended complaint signals that neither side is backing down. So there's that. Let me see if there's any other updates. We, of course, have a bunch of antis on X, like making complaints and saying things aren't true, but it is what it is. Okay, so this is Unfiltered Thoughts, Justice for John O'Keefe, also on X, at Facts Don't Lie 10. This is their take on the Ham amended complaint. It says the McAlberts state that they voluntarily testified in the federal grand jury. Since when is receiving a federal subpoena mean your testimony is optional? Very true. And second, they wrote that Karen Reed sent AJ's 92-page affidavit to Dr. Turtleboy, and they started conspiring to defame Jim McCabe. Not true. Aiden has said multiple times that he did not know Karen Reed when he first started covering the case. And it was because of this affidavit that he started becoming interested in this place, and it was sent to him by a Duxbury police officer. And that's actually what this tweet says. Jim McCabe is crying about Jen McCabe is crying about defamation because she Googled House Long to Die in Cold at 2:27 a.m. is hilarious. Actually, the entire defamation lawsuit is hilarious. John O'Keefe wasn't hit by a car. Jen McCabe made her bed. Now she can lay in it. Amen. Let me see if there's anything else. I don't care what Mama Llama has to say, or Julie Carpenter for that matter. All right, I think that's it. I am going to play the Monday song, and then we will get into testimony. We will not be covering the drama that went on last week at all. So I'm going to play the Monday song, and then we will get going. Oh, by the way, programming note, on Friday, I will be hosting a fundraiser for Edric Faust. I just put the link in the chat. Please go like that stream and share it far and wide. Okay, so okay, so like I said, I'm going to play the Monday song, and then we will get going with testimony. So I will be right back, everybody.
Alarm says move, I swing my feet. Cold floor, hard truth, but I'm on my feet. Coffee in a paper cup, keys in my hand. Same old plan. One deep breath, two step out. I know the weight, I know it now. Still I rise with a grin. This week starts here. Let me in. Monday, I'm ready. Monday, I'm ready. Watch me roll right through it. I got fire in me. Monday, I'm ready. Monday, I'm ready. One day at a time, and I'm where I should be. Yeah. Monday, I'm ready. Monday, I'm ready. Monday, I'm ready. Train pulls in, I take my seat. Rain on the glass and the rhythm in me. Inbox full, but I don't fold. I've been through worse, I've been told. Handed bound, you step out. I know the way, I know it now. Still I rise with a grin. This week starts here. Let me in. Monday, I'm ready. Monday, I'm ready. Watch me roll right through it. I got fire in me. Monday, I'm ready. Monday, I'm ready. One day at a time, and I'm where I should be. Yeah. Monday, I'm ready. Monday, I'm ready. If the morning bites, I bite back. If the day runs long, I stay on track. Not every step has to shine. I just need one, then the next in line. Monday, I'm ready. Monday, I'm ready. Watch me roll right through it. I got fire in me. Monday, I'm ready. Monday, I'm ready. One day at a time, and I'm where I should be. Yeah. Monday, I'm ready. Monday, I'm ready. Monday,
Okay. All right. Let me speed this up. Again, if it's too fast, do let me know. I usually listen to everything at 2.0 speed, so you know. But please let me know if it's too fast.
Yes, sir.
You have any idea how many times?
Probably no.
Ms. Lawson, I want to talk a little bit about the process of creating a composite drawing.
Okay.
And so kind of walk through that with me. How do you first meet with the individual that you're questioning and then go through that process if you can?
Okay. The detectives interview the witnesses and the victims and everybody, and they bring them to me. And I would show them a big, huge stack of old mugshots and photos of suspects and just old photos that I have in a big case that I dragged from pillar to post way back when. And I would tell them as they're looking at the photos, pick out anything that reminds them of the person: eyes, nose, shape of the face, teeth, hair, anything. Pull it to the side, and we would talk about it. And the average person would probably pull out 15 photos, and I would just draw it together into one face and hold it up, and they would help me change everything on it until we get it as far looking like the person that they remember, as they could. And I get them to rate it when we're done on a scale of 1 to 10, and as far as 10 being him and 1 not. So we just make corrections along the way, and
How long does this process take on average?
it probably takes 45 minutes per person.
And you mentioned kind of the ranking at the end. Is there a number by which you say, okay, like we're going to stop, or can you kind of describe that for me?
Yeah, I tell them to pick out a number between 1 and 10 as far as it looking like the person that we sketched, and they usually pull out I guess 3 photos for that too. You know, by this time I've got them accustomed to digging through the photos, and we try not to quit working on the sketch until at least we get an 8 on a scale of 1 to 10.
I mean, if the person were to give you an impression or a number that was less than 8, you would keep working. Is that fair to
Yeah,
say?
because in my opinion, anything below an 8, it's not worth circulating. But anything above an 8 or an 8 is a pretty good recollection of their memory.
Ms. Lawson, as you sit here today, do you have any recollection about coming to Athens, Clarke County to assist in an investigation back in January of 2001?
No, yes, I do. I don't remember drawing the 3 composites that I supposedly had to draw, but
Have you had a chance to look at them though?
I haven't even seen them.
Okay. Well, I'm just going to, if I can approach you.
Okay.
Ms. Lawson, we've got states 99 and states 100. States 99.
Uh-huh.
And what I want to point out there, ma'am, is do you recognize what's on the lapel of this individual?
Yes, sir.
What's
That's
that?
my
I
name.
gotcha. And then on states 100, I didn't see one there.
Well, you get busy and you get in a hurry, and
Okay.
you might not get them signed, or you might get them signed. I mean, you know, I'm kind of haphazard.
All right. Let me just give me just 1 second, Ms. Lawson. I want to make sure I didn't miss anything. Ma'am, I don't have any further questions for you. The defense counsel may have some questions. Thank you, ma'am.
Mr. Cruz, cross-examination.
Good morning, Ms. Lawson. How are you? I'm doing okay, Ms. Lawson. I'm maintaining. Thank you for being here today. I just have a couple of questions for you, if that's okay. I'd like to show you a couple of the pilot sketches that you did in relation to sightings in this case. I'm going to mark those exhibits as Defense Exhibit 23 and Defense Exhibit 24.
I do have an objection to these exhibits, Your Honor. It's under 401 and 403.
All right. Let me ask you this question, Mr. Golden. Do you have an objection to the admission of those exhibits? Okay. All right. I'm going to let you get started. And if you choose to try to tender them, I will hear your objection.
Yes, ma'am. Thank you. Ms. Lawson, do you recall completing sketches on Friday, January 26, 2001? I'd like to show you, and would you recognize those sketches if you saw them? I'd like to show you 2 sketches. Do you let the record reflect that I've shown Ms. Lawson Defense Exhibit 23 and Defense Exhibit 24. Do you recognize Defense Exhibit 23 and Defense Exhibit 24?
Yes, sir.
Okay, and these are sketches that you did for Athens, Clarke County on January 26, 2001? Yes, ma'am. Do they appear to be altered in any way?
They don't look like it, do
No, ma'am, that's my knowledge. Your Honor, I would move to admit Defense Exhibit 23 and 24, and I could respond to the state's relevance objection.
I do have an objection under both 401 and 403.
All right. Do you care to elaborate?
Yes, Your Honor. Well, one, none of the witnesses that would have potentially given a description to Ms. Lawson have been in court and testified. I mean, I do think we need to address some of this outside the presence of the
All
jury.
right. We will do that then. Ladies and gentlemen, I'll have you go sit in the jury room. Go discuss the case. We'll be with you shortly. And while the jury is leaving, I'm just going to say for the audience, there are a number of people in here who may not have been here yesterday. So I want to make sure everybody understands the court's rule about cell phones. With the exception of the media, who has permission to have cell phones, with the exception, of course, of counsel and their staff, and with the exception of law enforcement and attorneys who are working in this building today, with those exceptions, everyone else is not permitted to have their cell phone out and in use. So if you have a cell phone, just make sure it's tucked away and turned off. Obviously, we don't want it going off. Thank you very much. All right, y'all may be seated. Go ahead, Mr. Golden.
Your Honor, what Mr. Cruz is attempting to introduce through Ms. Lawson, she did. I mean, I'm not denying that those are sketches that she made at Athens Clarke County Police Department back in January of 2001 in relation to this case. What I would say, Your Honor, is that those sketches are from witnesses who described seeing an individual in Deer Park days before January the 19th. I mean, if Mr. Cruz asserts otherwise, he's mistaken. So these are not relevant. And so not only are they not relevant, any potential, just the fact that there were people that came to the police department and that gave descriptions to Ms. Lawson on that day in connection with this case is relevant under 401. And I think that the state's argument would really stop there. But even if there was some sort of probative value of that evidence, that it would be substantially outweighed by the risk of confusing the jury, because at this point we don't know who gave those descriptions and things like that. So these are not admissible in the state's view under both 401 and 403.
All right, Mr. Cruz, any response?
Yes, ma'am. Under OCGA section 24-4-401, the term relevant evidence means evidence having, and emphasize the language any, or the word any, but any tendency to make the existence of a fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. And as the court is aware, the threshold for relevant evidence is extremely low. The relevance of these photographs are that, the relevance of these photographs is that law enforcement, when they were speaking to individuals in the neighborhood, the individuals that they requested sketches of, as the court is aware from the other states' exhibits, are any African-American individuals that were seen either the day of the crime or the day before the crime. I believe I'll say this, and Mr. Bowden has something to counter that, but one was December 18th, which I believe is not December, please forgive me, January 18th, which was the day before the murder, but law enforcement found it relevant, and Ms. Lawson completed a sketch. The other one was an individual they did see in this one on January 19th. So the evidence is relevant to the issue of, on one hand, we have a young lady saying, hey, I see a guy running. She tells law enforcement that. No sketches requested of that individual. However, law enforcement did request sketches of African-American individuals that were seen the day before, as well as African-American individuals that were seen not even at the scene, but the day of the fire taking place. Those are the individuals that they chose. So that's in response to the relevance objection by the state. And I know sometimes I confuse my words. Did I explain that wrong to the honorable court? Did I confuse the honorable court in any way?
I'm not confused.
Yes, ma'am. In regards to confusing the jury, I made it clear in my opening that law enforcement dropped the ball a couple of times. And this is a part of that. We have law enforcement getting sketches from January 18th. We have law enforcement getting sketches from a person, I think he was at the corner of Cooper Road, which is this individual, and Fun Drive. But yet we have a young lady who explained to law enforcement that, hey, I saw this guy running. And law enforcement did not ask Ms. Lawson or that individual to complete the sketch. So that would be my response to the 401 objection, as well as the 403 objection, Your Honor.
All right, thank you, Mr. Cruz. Yes, sir.
So I would also point out, Your Honor, that the state did file a motion. Soddy motion is what we've been referring to it as throughout all the pretrial hearings and as we've gotten into the case. And, the law is very clear that Mr. Cruz has to proffer that in advance for exactly this moment. The only person he identified in that Soddy motion was Chris Melton. So, and the whole purpose of that is for the court to be able to undergo a preliminary 403 analysis. I cited the cases to the court. I just remind Your Honor, among those being the Crumpton case out of the 11th Circuit. And so there is a substantial risk. Any probative value is substantially outweighed. And I'm not saying that there is a probative value, very clear, Your Honor, but any arguable probative value is substantially outweighed by the risk of confusing the jury. And I just don't think it's admissible.
Thank you. Anything further, Mr. Cruz?
I mean, that's my argument in regards to the 401 objection as well as the 403 objection.
Thank you. All right. With regard to this offer of these two sketches at this moment in time, I don't find them to be relevant.
Yes, ma'am.
The evidence has been described as being related to a sighting of someone not on the date in question, and also the other one not in the vicinity of the incident in question. So I'm going to grant your motion. I will say this: should the evidence, as it goes forward, tend to establish relevancy, we can revisit this issue. But for now, I'm going to grant your motion. I do also find, in granting your motion, Mr. Bolden, that you have made a proper argument over 403. I think at this point, given the description, Mr. Cruz, that you have provided about where those two sketches came from, it is certainly falls under the description in 403 of confusion of the issues. And so I'm going to grant your motion at this time.
May I ask the honorable court? I know we have Court's Exhibit 1, which was the PowerPoint. I don't know if the honorable court issued a ruling on that, but which was the PowerPoint from the state. I asked the honorable court to admit as Court's Exhibit 1. Can we admit Defense 23 and 24 as Court's Exhibit 2 and Court's Exhibit 3 for the purposes of the record?
No.
Yes, ma'am.
All right. You may bring the jury out. Thank you. Yes.
I just thought maybe the issue with Ms. P.B. Hall we could address now.
Go ahead. No, go ahead, since the jury's not here.
I'm not going to say the address again
Sure.
on the record, and I don't think it went out on the broadcast, but I do want to let the court know that my understanding, after having spoken with our Director of Victim Services, is that that is the correct address for Ms. P.B. Hall, that she has not received a subpoena.
Right.
She began checking because she was notified by Dr. Lowe when Dr. Lowe received hers, but she is unaware of any subpoena that was mailed via, I guess, certified mail.
All right. Thank you. Mr. Cruz, any comment? You want to speak to the staff that Mr. Yelman talked about?
I do not. As I mentioned to the honorable court, I think you made your ruling on the subpoena issue, which I would abide by, of course. I'll just I'll perfect the record with a copy of the certified tracking and return receipt information.
All right. Thank you, sir. You may certainly do that. I'm going to allow Ms. Ashley Peavy to remain in the courtroom if she chooses. All right. Will you bring the jury in, please? Thank you. Thank you. Y'all may be seated. Mr. Cruz, you have the floor.
Thank you, Your Honor. Ms. Lawson, please forgive me. In regards to your process, I understand that you have them look at photographs, and from there they pick the shapes and different portions, eyes, things of that nature that fit the individual that they see. Is that correct? Okay, and I've had opportunity to look at the Eric Rudolph sketch. I'm sure you have because you've completed it. Typically, when you complete sketches and they're on the 8 scale, as you mentioned, are they pretty much similar to the person's description, accurate to the description that you received? Okay, excellent. Do you keep any notes in regards to those pertinent, or at that time, would you keep any notes in regards to the pertinent facial features that individual described?
I fill out incident reports, each composite drawing that I do, and we'll sometimes, state whether or not I had any problems or anything was said about, when we were complete, and should they circulate or whatever. Did they feel good about it? But that's how we determine the completed, thing.
Absolutely. So there's I'll let you show you a document. As for your patients, I'll let you show you a document that I'm going to mark as Defense Exhibit 25. Let the record reflect that I am showing the state what has been marked as Defense Exhibit 25. Okay, if I approach Ms. Lawson.
Okay.
All right, in regards to Defense Exhibit 25, is that the document that you're speaking of when you say report, or is it a separate document?
That's the document.
This is the document. Okay, excellent. Your Honor, you recognize this document, correct?
Yes, sir.
Okay, and is it a fair and accurate depiction of the document as you remember creating?
Yes, sir.
Okay, and does it appear, outside of the Defendant's Exhibit sticker, does it appear to be altered in any way?
No.
Your Honor, I would move to admit Defense Exhibit 25 as evidence.
Any objection?
Generally, no. I think that based on the court's ruling just a few minutes ago, parts of it would have to be redacted. So
All right.
subject to that redaction, I don't have any objection.
All right, Mr. Cruz, you want to be heard on Mr. Bolden's comment, redaction.
Yes, I do. Well, portion though, just let me make sure I'm understanding.
Sure.
In regards to the state's objection, I do believe based on your prior ruling, I would not be able to admit that evidence. So I don't have any objection.
All right, so I just want to make sure we're clear that state doesn't have any objection over the admission, except for certain portions that need to be redacted based on my ruling, and you agree with that.
I don't agree, but I respect
You're not
your
objecting to
position.
that.
Correct, yes,
Okay.
ma'am.
All right.
And I just want to be clear because what I think I heard, and correct me if I'm wrong, is that he's now not intending to tender the document.
No, that's incorrect. I do intend to tender the document, Your Honor.
But you're not objecting to the comment, the argument that Mr. Bolton made about certain portions need to be redacted according to the ruling the court has made.
Correct.
All right, then I will admit it with that understanding, and it can't be certainly circulated to the jury until I take a look at that document. We all agree what needs to be redacted, but I will admit it. Go ahead.
So in regards to, I may need to give you this. In regards to suspect number one, the composite reconstruction notes, would you agree that you put that the male was black? Is that fair? He was 18 through 21 years of age.
If you could just answer with your voice, yes or no?
Yes.
Thank you very much.
Thank you. He has an orange shirt. Is that correct?
Yes,
Medium brown complexion. Is that right?
yes,
Short 2-inch afro. Is that correct?
yes.
I need to ask you a question about something. I'm personally.
Nay.
Yes.
And slight mustache. Is that correct?
That's right.
Okay. And I'd like to show you what has been marked as the Defense Exhibit 99. I'll give you some of these, right? I'm not sure. With the description that we put in our report, which exhibit does that description apply to?
No, I don't know.
That's fair.
Either the suspect one or two, but I think I should have wrote it maybe across the top maybe, so we, this long gone for a time period, could have figured out who was who.
Yes, ma'am. In regards to Ms. Tiffany Riker, I'm going to show you what's been marked as Defense Exhibit 25, okay?
Okay.
In regards to Ms. Tiffany Riker, we don't have a description that she provided. Is that correct?
Let me see. I wrote anything there. No, but the suspect two was listed.
Your Honor, this is what we're getting into. Like that. State's objection was the same as to portions of that document being redacted, and now again, Ms. Lawson's been questioned about the parts to be
All right,
redacted.
let me see counsel to the bench with the exhibit, please. I didn't hear a question. I mean, she may have started talking about what is it?
Is it?
Posits, you know.
Yes, ma'am. Is it a description of the individual that she saw as well? They also introduced evidence from Ms. Karen Williams, she gave a description of the individual that she saw. So we do actually have three. We have four, but outside of those three, we do have three individuals that have stated that they saw a black male walking in the neighborhood. We can also add four with the witness that came in today and mentioned the individual that he saw walking down the street as well. So I don't think it would confuse the jury because they've already heard evidence of multiple individuals in the neighborhood. John.
All right, thank you. All right, so that gives me a better explanation of where you are coming from, Mr. Cruz. So this is sort of a two-part moment. The state's argument that this violates 403, I think, is accurate. I'm going to grant your motion because it's in relation to this witness, regardless of what you've just mentioned. And I will talk about that because I don't mean to suggest that is, I don't mean to be flippant in that way, but I want to talk about your specific argument. With regard to this witness has been identified as the person who made the two sketches that are in evidence, And so the state's argument that this cover letter, and I don't find it to be relevant, but regarding 403, the state's argument that this cover letter violates 403 is appropriate because it refers to three different sketches. It, in this particular moment with this witness, does certainly create confusion of the issues.
Yes, ma'am.
I am not prohibiting you from discussing the testimony in the way that you have just described it. You have described the four witnesses that the state has presented, talking about a person they saw in the neighborhood as being four different suspects. The state may choose to refer to those witnesses' testimony differently, but I'm not prohibiting you from talking about those the comments that the witnesses have made in court about the person that they saw in the way that you've just described.
Yes,
but with regard to this witness and this exhibit, I am going to sustain your objection.
Your Honor,
I'm going to grant your motion, sustain your objection.
yes,
For those reasons.
Your Honor, for the purpose of the appellate record, would the honorable court be willing to admit this as court's exhibit? I believe it'll be 4.
I don't think that's appropriate, Mr. Cruz. I'm not
Yes,
going to do that. All right, I'm going to give this back to you. All right. Anything else before we bring the jury back in?
Your Honor.
All right, Mr. Cruz, you ready for the jury?
Yes, ma'am.
All right, thank you. You may bring the jury back in. You all may be seated. Thank you. Mr. Cruz?
Yes, ma'am. Ms. Lawson, I want to thank you so much for your time. Those are all my questions.
Oh, thank you.
Thank you.
Any redirect, Mr. Bolden? May this witness be excused? Mr. Cruz, any objection?
No, ma'am.
All right, thank you. You are excused from any further service. Mr. Bolden, did you care to call the next witness? Is this a witness that we can call and then take a lunch break?
We could, Your Honor.
All right, very good.
Well,
Wait,
yeah, we can.
all right, we're going to do that. And who is your next witness that you care to call?
Kylie Traub.
Could you please get Kylie Traub?
Just make sure I'm right. Ma'am, if you could raise your right hand, please. You swear or affirm your testimony in the matter pending before the court should be the truth, the whole truth, and nothing but the truth, so help you God. Okay, you can have a seat. Ma'am, if you could state your name and spell it for the record, please.
My name is Kylie Traub, Kyleeetraub.
Ma'am, how are you employed?
I'm employed as a latent print examiner at the Georgia Bureau of Investigation in the Division of Forensic Sciences, and this is commonly referred to as the State Crime Laboratory.
What are your responsibilities in the, at the crime lab?
My responsibilities include, but are not limited to, processing evidence for the presence of latent prints, photographing any latent prints that are developed on these items, conducting comparisons of latent fingerprints to known fingerprints, running searches on the FBI NGI database as well as the Georgia APHIS database, and writing all of my conclusions and report that I can testify to in court.
Can you tell us a little bit about your education, training, and experience as it relates to that job responsibility?
I received my Bachelor of Science degree in chemistry from the University of Wisconsin-Green Bay. I then completed the 20-week National Latent Print Examiner Training Academy in Meridian, Mississippi, as well as the latent print processing and latent print examination training programs at the GBI.
And can you testify generally about how one might search for fingerprints on items of evidence?
So for items of evidence, they are typically processed based on what type of evidence they are. So a non-porous item such as glass, metal, or plastic would be processed one way, whereas porous items such as paper, cardboard, or things like that would be processed in another manner.
Okay. And why would that be the case? Why would there be a difference in the way that they're tested?
The difference is due to the non-porous items, your glass, metals, and plastics. These items are normally smooth and shiny surfaces, so a fingerprint could be easily wiped off. It's not going to be absorbed into that surface. So we are trying to preserve those as best as possible. And then a porous item, paper, cardboard, these items are going to more absorb the fingerprint residue. So we are going to apply different chemicals to be able to make those visible to the naked eye.
Have you had the opportunity to come to court to testify before about latent print processing at the GBI Crime Lab?
Yes, I have.
Approximately how many times?
Approximately, I believe 7 times.
And during those times that you previously testified, have you been qualified as an expert?
Yes, I have.
In what areas?
In the area of latent print processing and examination.
At this time, Your Honor, I would move to tender Ms. Traub as an expert in latent print processing.
Any objection, Mr. Cruz?
No, ma'am.
This witness is admitted as an expert in latent print processing. Go ahead.
Thank you, Your Honor. Ms. Traub, did you have the opportunity to test certain items of evidence for the presence of or lack of presence of latent prints in connection with the case involving a victim by the name of Tara Baker?
Yes, I did.
Okay. And if you are aware, were certain items tested back in 2001?
Yes, some of the items that I tested were previously tested.
And what would be your reason for then going back and retesting them?
We have some new chemicals that we did not have in the past that we have access to now to conduct more testing.
Are you aware of what the results were back in 2001?
I do not know exactly what processes were applied, but I do know what the results were, yes.
What were those?
Those were negative results.
I mean, there were no prints.
That means there were either no prints that were potentially suitable for comparison or, yes, no prints at all.
Nice.
This has been Martin States 107. Actually, hold on to that for the time being, okay? You mentioned testing some items of evidence as it relates to this case. Was one of those things a power transformer?
Yes.
And all right. So, do you recall what testing procedures you performed on that piece of evidence, ma'am?
If I'm able to refer to my notes, I do.
Absolutely.
For the power transformer, I would have conducted a visual examination where I look at the item of evidence as it was received to see if there are any visible latent prints. I then applied a chemical known as lumicyano. This is a fluorescent superglue, so any latent prints that are developed would also fluoresce so that I could look at them under a light source. And then I also applied what is known as powder in suspension. This was a white in color chemical, and this can render any fingerprints that might be in blood visible to the eye.
Moving along to the next piece of evidence, that the ninth set? The knife block, referred to as, I'm going to use the crime lab's number, item 13.
Yes.
Do you recall performing testing on that piece of evidence?
Yes, I do.
And what testing did you perform on it?
For the knife block, I also started with a visual examination. This was followed by lumicyano, again, the fluorescent superglue. I then applied DFO and anhydrine. These are chemicals that are used for porous processing. Since the knife block was made of wood, it would absorb fingerprint residue. So I applied those chemicals to look for that type of evidence.
Okay. Next, I want to talk about item 14, and using the crime lab number. Is that some stove knobs?
That is correct.
Can you describe the testing you conducted on the stove knobs?
On the stove knobs, I conducted my visual examination followed by the lumicyano.
Okay. And then lastly, on states 15, I'm sorry, crime lab 15,
Yes.
states 94. Excuse me. What item of evidence was that?
This item of evidence was a knife.
What testing did you perform on the knife?
On this knife, I performed my visual examination followed by lumicyano and the white powder in suspension.
As it relates to all four of those pieces of evidence, can you testify as to the results of your search for fingerprints?
For all of those items, the results were negative for fingerprints.
And is States 107 a report that fairly and accurately summarizes the testing that you performed and the conclusions that you reached?
Yes.
And is it signed and dated by you? Or signed with a date on it, I guess?
It is signed with the date that the report was released, yes.
The tender States 107 at the time?
Any objection?
Yes, sir.
Any response to the hearsay objection, Mr. Bolden?
No, Your Honor.
Okay, I will admit it over objection.
Ma'am, those are all the questions I have. Defense counsel may have some questions. Thank you.
Mr. Cruz,
I have any question for you. Thank you for your service.
may this witness be excused, Mr. Bolden?
Yes.
Any objection by the defense?
No, ma'am.
You are free to go.
Thank you.
You may call your next witness.
Your Honor, now might be, I think we're going to get into,
Well, we're waiting for lunch to arrive for the jury, so we're going to keep going.
bear with me just a second.
All right. Okay, run down.
Judge, can I step into the hallway for just a
Sir.
minute, make sure the witness is out there?
Yes.
We will have another witness.
All right. Yes.
While Mr. Yalmanchili is tracking down that witness, I did just get a text from another witness that the state could put up, and I'm comfortable doing that while he tries to run that person down.
That's totally fine with court. I mean, it's your case.
John Newton?
Could you get John Newton? Thank you.
Sir, if you could raise your right hand, do you swear or affirm that your testimony in the matter pending before the court should be the truth, the whole truth, and nothing but the truth, so help you God? Okay, you can have a seat. You could state your name and spell it for our court reporter, please.
My name is John Newton, John Newton.
And Mr. Newton, going to refer you back to 2001. Where were you employed at that time, sir?
I work for the Athens Clarke County Police Department.
How long did you work for the Athens Clarke County Police Department?
12 years.
Okay. And during that time, were you a post-certified peace officer in the state of Georgia?
Yes, sir.
And what is that? What does post-certification mean?
Post is the standards council that creates the standards for police officers for what it means to be, I guess, be an accredited police officer in good standing.
Basically, a sworn officer, is that fair to say?
Yes, sir.
And did you work anywhere else in law enforcement after Athens Clarke County?
After? No, sir.
Okay. Back in 2001, did you help with other officers in the investigation into the sexual assault and murder of Tara Baker at 160 Fawn Drive?
Yes, sir.
And are you familiar with that, where that address is?
I'm familiar with the general area. I don't think I could drive you to right where it is, but right off of Lexington Road, near the church and that neighborhood back in there.
Is that in Clarke County?
Yes, sir.
Now, I know you had a lot of involvement in that case, but I want to focus on just a few very specific things. In the days immediately following Ms. Baker's death, did you have an opportunity to collect head hair samples from certain persons in Tara's orbit?
Yes, sir.
Okay, did that include known hair samples of her roommates, Ashley Peavy and Valerie Lang?
I believe so, but off the top of my head, I couldn't tell you. Like, I would have to look at my report.
Would that help refresh your recollection?
Yes, sir. That would be wonderful.
Yeah, I appreciate it, John.
You may.
Thank you. Yes, sir.
Actually, same question. Did that include collecting known head hairs from her roommates, Ashley Peavy and Valerie Hall?
Yes, sir.
Did it also include collecting head hairs from Chris Melton?
Yes, sir.
You may.
Then I'm going to hand you a mark that states 108, 109, and 110. Do you recognize those items, sir?
I recognize what they are. I can't say like off the top of my head,
Sure.
This is it, but yes, this is my handwriting on these, and these would be evidence bags.
And do you take your time to review those items in their entirety? On each of those items, do you see your name or initials on a piece of evidence tape?
Yes, sir. My initial is on, or my signature and or my initial, and my handwriting is on each of these.
And what do they appear to be?
One is the known head hair of Ashley Peavy.
Is that 108? With the evidence stickers?
Yes, sir.
States 109, what is that?
Known head hair of Valerie Lang
And then 110?
is the known head hair of Chris Melton.
And again, just to be clear, when you collected each of those items, 108, 109, 110, what would you have then done with them?
Put them in the bag, sealed them, put my initials on them, and placed it in an evidence locker.
And from that point on, would you have any idea what may have happened to those pieces of evidence?
I would have an idea, but I wouldn't do anything with them. I mean, I put them in there for the purpose of, further examination, but I wouldn't be involved in that.
I would move to tender states 108 through 110 at this time.
Any objection?
Lack of foundation, one, we don't. First, lack of foundation. We don't know if anything is in the bag. I would ask that the witness is allowed to identify what's in the bag. Two, if the bag is what the state seeks to introduce with the writing of whose name it is, I would object to relevance, as the bag is irrelevant to any issue in this case. It's what's inside of the envelopes. So those are my two objections.
Thank you, Ms. Cruz. Ms. Bowman, care to respond before I make a ruling?
No, Your Honor.
All right. The foundation has been laid for the purpose of admission of evidence. I'm going to admit them over objection.
I'll take those back from you. And then at some point later, in your participation, it's hard to say, in this investigation, did you have the opportunity to once again meet with Chris Melton in an attempt to obtain his pubic hair samples?
Yes, sir.
Okay. And as you sit here today, 25 years later, do you remember exactly when that might have been?
Not without looking at my report, sir.
May I approach again?
You may.
Take a minute and see if that helps refresh your recollection.
Yes, sir.
Having had a chance to review what I just said, does that help refresh your recollection as to when you would have elected known pubic hairs Chris Melton?
Yes, sir. It was on February 27th of 2001.
Where did that take place?
This is the GBI office in Gainesville.
May I approach, Your Honor?
May.
One last thing. Stage 111. I can take a look at that.
Yes, sir.
And do you recognize that?
Again, I recognize my handwriting and everything's on it. Right. It's a evidence bag with my handwriting and my initials and the date of February 27th, 2001.
Does it have markings that would indicate what?
Oh, I'm sorry. It's the known pubic hair of Chris Melton.
I move to tender States 111.
Any objection, Mr. Cruz?
Yes, ma'am. Like a foundation to the item that's in the bag, and Rule 401 is relevant to the state's intending to just introduce the bags.
Mr. Bolden, any response?
Your Honor, it is relevant. Mr. Cruz has made chain of custody an issue in this case, so we're attempting to introduce the bag. The state will then go on to introduce what the contents of the bag. And so this is necessary for a first step, so I think it is relevant.
I'm going to admit it over objection.
And again, kind of like before, Mr. Newton, when you collected those, how would you have them package them in item States Exhibit 111?
Right. Who would take the evidence, put it in the bag, seal the bag, and put it in the evidence locker.
And understanding as before, you might have some idea about what happens from that point forward. Did you have any further involvement with States Exhibit 111?
I did not.
Sir, those are all the questions that I have at this time. Defense counsel may ask questions.
Mr. Cruz, cross-examination.
Good afternoon, Mr. Newton.
My name is Cruz.
I did not know you would be testifying this fast, so forgive me.
I did not know that either.
I have a couple of questions for you. Is it okay?
Yes, sir.
Thank you. On January 21st, 2001, do you recall capturing pictures of Mr. Chris Melton's hands?
I apologize, Mr. Cruz, but I do not. I probably wrote a report, and if I could look at the report, I could tell you. But this long afterwards, I can't say that I have an independent recollection of what happened.
Yes, sir. That is fair. So what I would do, I'm going to provide you a copy of the report as well as the photographs to give you a
Yes, sir.
look over. Is that okay?
That's great, sir. Thank you.
I haven't seen them, Your Honor.
Yes, sir.
Yes, sir.
Do you recognize those photographs?
I'm not sure the appropriate way to answer this. I recognize what the photographs of and what this says. Do you by chance have a report that I wrote with this?
I may. Of course, indulgence.
But I mean, I recognize the photo log and what's listed here, and what the pictures are of.
What are those pictures of?
These are pictures of hands along with a ruler showing injuries to a hand,
And can you?
and the fingers, back of the hand, those sort of things.
And do you recognize that property sheet?
This is my handwriting on this property sheet. It's a property sheet that I filled out on January 21st, 2001.
Okay. And it states photographs of Chris Melton's hands?
The photo log states that, and then the sheet that says it, and then the evidence sheet says are pictures of Chris Melton. But you're right, the photo log shows what each specific photo was of.
Sure. And that's the report I was looking for. I realized I gave it to you. So yes, that is the cover sheet, and the following photos would be what was included in the discovery.
Yes, sir.
That's it. Do those photos appear to be a fair and accurate depiction of the photographs that you took of Mr. Melton's hands?
Yes, sir.
Do those photographs appear to be altered in any way?
They do not appear to be altered to me. No, sir.
And you will. Let the record reflect that I am marking Detective Newton's property and evidence record sheet of pictures of Chris Melton as defense exhibit 28.
That's what I have. I think that's right, Ms. Cruz.
Yes, ma'am. Thank you, Your Honor. And let the record reflect that I am marking $14 photographs of Chris Melton's hands as defense exhibit 29. Detective Newton, I have a few more questions for you in regards to the property form. I want to make sure I lay the proper foundation for that form.
Yes, sir. Yes, sir. Thank you.
And you testified that you recognize the document. Does it appear to have been altered in any way?
No, sir. It does not appear to have been altered.
And is it a fair and accurate, or is the document a fair and accurate copy of the document as you would remember it?
Yes, sir.
Thank you. Your Honor, I would move to admit defense exhibit 28 and 29 as evidence.
Any objection? They are admitted.
I would ask for permission to publish defense exhibit 29 to the jury.
Granted.
And Detective Newton, you would agree that those photographs were taken 2 days after Ms. Baker's death?
Okay. I would agree they're taken on that date. I apologize. I don't remember the exact date of the incident, but on the date that's listed there, I would agree. Yes, sir.
Okay,
January
January.
being that that's probably 2 days, an answer yes, but I apologize. I didn't review very few things before coming here.
That's on me. So I'll say this.
But the date on that would be the date that all that would have taken place. Yes, sir.
That is January 21st, 2001.
Yes, sir.
Thank you. Do you recall obtaining phone records from Ms. Tara Baker?
I don't recall that specifically, but I would be surprised, if that's not something we did.
Would seeing for purposes of the record, it is a copy of Detective Newton's affidavit in reference to phone records court order for the phone number 706-316-9760.
Your Honor, I would again ask that Mr. Cruz show me something before he tries to hand it to a witness.
That's correct.
I apologize. I'm too fast. I'm sorry. Is it okay if I-
Yes, sir. Thank you.
And after you've had opportunity to review those records, just look up. I'm going to have a couple of questions for you about those records.
Yes, sir.
All right. Have you had opportunity to look at the documents provided to you?
Yes, sir.
Okay. What would you describe those documents as?
Phone records for the phone number 706-316-9760. So they show phone calls, time of duration, whether it's answered or not, carriers involved in some instances. It has dates and times of the calls.
Yes, sir. And would you have any reason to agree that those are Ms. Tara Baker phone records?
That's certainly what they appear to be.
May I approach you?
Yes, sir. Thank you, sir.
Let the record reflect that I provided you with a pen and a sheet of paper. Is that correct?
Yes, sir. Blank piece of paper with lines on it, blue pen.
And you're actually going to need these.
Yes, sir.
We've already agreed that those records that you have are Ms. Baker's records, correct?
Yes, sir.
Would you mind writing on that sheet of paper Ms. Baker's phone number based on those records?
I would object. He is asking the witness to testify about an item that is not in evidence.
Any response, Mr. Cruz, to the objection?
No, ma'am. This witness has personal knowledge of those items, so I would just ask that I have no response other than this witness has personal knowledge of.
I mean, with regard to the evidentiary objection, Mr. Bolden, he is correct. I'm going to sustain the objection.
Yes, ma'am. Court's indulgence.
Yes, sir.
Let the record reflect that I am marking the items identified. I know I've been calling you Mr. Newton. It just feels so natural to call you Detective Newton. Can I call you Detective Newton?
Sure.
Okay. The items, let the record reflect that I am marking as Defense Exhibit 29.
You've done 29. I think you're on 30. I think that's right. Do you have that, Ms. Satterfield? Thank you. Yes, number 3.
Let the record reflect that the items that Detective John Newton has identified as Ms. Baker's phone records have been marked as Defense Exhibit 30. And that's in regards to number 706-316-9760. Let the record reflect that I am showing the state what has been marked as number, Tara Baker phone records, Defense Exhibit 30. And do these phone records appear to be altered in any way?
No, sir, they do not.
And is this a fair and accurate depiction of the phone records as you remember seeing them 20 plus years ago?
It's a fair and accurate representation of what we would receive as phone numbers. Again, I don't know that I have any independent recollection, but to the best of my knowledge and ability, those would be the phone records.
Yes, sir. Thank you. Your Honor, I would move to admit into evidence Defense Exhibit 30.
Any objection?
I don't think that's a proper foundation for the admission of business records. So I do object to Mr. Cruz attempting to tender those records for this witness.
All right, Mr. Cruz, any objection before I make a ruling? Any response before I make a ruling about the objection?
Sure. So Detective Newton obtained these records via a court order. So I do believe there's, to respond to their objection, he received these records via a court order, Your Honor.
I don't think that overcomes, though, the objection that the state has produced, which is that it's not a proper way to introduce business records. So I'm going to sustain the objection.
Yes, ma'am. Court's indulgence. May we take a 5-minute break, Your Honor?
Well, I think this would, well, yes, we can. The answer is yes, but it may be more than 5 minutes. So can I see counsel at the bench about timing issues? All right, thank you. Yeah.
Day.
All right, thank you. And I'll respond to that. And Ms. Cruz, do you want to say anything about that announcement?
No, ma'am.
All right, thank you. I mean, that sounds fine. I mean, it is almost 1:45. You may be surprised that we may not be finished until 5. It's not really that much longer, but that's fine. As soon as we're finished with your fact witnesses, we will go into the Daubert hearing. I think that makes sense. All right, anything else before we bring the jury up from the state?
No, Your Honor.
All right, Mr. Cruz, anything before we bring the jury out?
No, ma'am.
All right, thank you. You may bring the jury out. Everyone, you may be seated. Thank you. Mr. Cruz, you have the floor. We're back on the record.
Sure. And I think before we broke, the state had an objection to the introduction of phone records. I responded and asked for a short recess to look over the law regarding those records. The question I have, I don't think Mr. Bowden was specific with his grounds for objection. If I remember correctly, he said that it was inadequate or inappropriate foundation for business records.
Are you talking about Exhibit 30?
Yes, ma'am.
I've already sustained the objection. If you would like to put some case law on the record, you may, but I've sustained the objection.
Yes, ma'am. Understood. What was the specific objection? Just so I could.
I actually don't remember. I don't write that down. We'd have to go back in the records. If you don't remember and not prepared to present some case law, and I'll let you put case law on the record if you want to. But we need to move forward.
I'll ask this. Can I be heard in regards to his objection? I can't. What I'm asking is, I don't know what the specific legal ground of the objection. I remember he said something that the court agreed to and granted, but in order for me to perfect the record, I would just need to know the specific legal ground. If he's
Well, I will just say this, counsel. I'm going to ask you to move on with this witness. I already gave both parties the opportunity to respond, and so I'm going to ask you to move on.
Yes, ma'am. On March 12, 2001, do you recall receiving a message from a female inmate at the Clark County Jail? No.
No, sir, I do not.
Mr. Cruz, if you'll go ahead and show Mr. Bolden what you're going to be working with. Thank you.
Thank you, sir.
And of that document that I provided you, the specific portion to read is paragraph 1, sentence 1.
I checked, Your Honor. I don't know that there was a question. I don't know that the witness said that there was a maybe I'm mistaken, but that was.
I think that's right, actually. I think you need to sort of start over and lay whatever foundation you need to with regard to this document.
Yes, ma'am,
All
we
right,
do.
go ahead.
On March 12th, do you recall receiving a message from a female inmate at a Clark County jail?
Yes, sir.
Okay. And what did she, she messaged you because she wanted to speak with you about the Tira Baker murder, is that correct?
Yes, sir.
Okay. And you met with her upon receiving the message from her, is that correct?
Yes, sir.
You went to the jail and spoke with her, correct?
Yes, sir.
And she provided you information about who she believed committed Ms. Baker's murder, is that correct? And it'll be paragraph 3 if you're looking at the report, sentence 1, 7, and 9.
I do have an objection on the motion that the state previously filed. And
Can you bring that microphone towards you, Mr.?
Same as before, Your Honor.
Okay, Mr. Bolden, will you bring that microphone towards you and just repeat your discussion?
Same objection as before. This state's previously filed a motion. I don't think this is relevant under 401. I think it's 403. So I do object to this line of question.
What previously filed motion are you referring to?
The Saudi motion, Your Honor.
Okay, all right. Based on our prior discussion of those kinds of objections, I'm going to send the jury out again. So if you'll go back into the jury room, please don't discuss the case. Thank you. Thank you. All right, y'all may be seated. Mr. Cruz, do you want to make any more of an objection? Let Mr. Cruz respond.
Yeah, Your
All
Honor.
right, Mr. Cruz.
To make sure I understand the legal basis for the objection, Mr. Bowden has stated Rule 401, which is relevant. Rule 403, I would ask the specific grounds under 403 that wasn't stated in the Saudi motion. But if I could get the specific grounds for 403, I could address all three, Your Honor.
All right, Mr. Bolden, specific grounds that you were referring to.
403, Your Honor. I think that this, what I expect the line of questioning that Mr. Cruz intends to ask of the witness would go to potential alternate suspects, alternate perpetrators. The state did file its motion back in October, specifically related to these types of issues. We, at our hearing on January the 21st of this year, Mr. Cruz indicated that the only alternate perpetrator that he intended to identify was Mr. Melton. I think that's been very clear throughout this trial to this point. And so what I suspect he's attempting to do here is to run through every tip or piece of information that the police got relative to anybody over the course of this 25-year investigation, not all of them through this witness. But one, my first point is that the motion that the state filed back in November and that we heard arguments on the 21st, the court granted my motion, granted the state's motion, and except with respect to Mr. Melton. So, to the extent that Mr. Cruz may now be trying to assert that they're alternate perpetrators, that's the whole point of the motion. There has to be evidence proffered to the court before he can ask that type of information in front of the jury, so that the court can make a determination about whether or not any probative value is substantially outweighed, and I will be specific here, confusion of the issues and waste of time. So that is the state's objection.
Thank you. Ms. Cruz.
If I may, I don't quite understand. It was a lot of information, forgive me. I understand he mentioned something about Saudi. Can I get clarity on that, Your Honor? If you understood what Mr. Bowden was mentioning in regards to
Well, he was just, again, mentioning the hearings that we had about the 412 motion and the rulings.
the rape shield statute.
I'm sorry, not rape shield, Your Honor. The one that I'm specifically referring to, and it was captioned.
That was also on the 21st.
Right, and it was also filed by the state on the same day, which is state's motion in limine to require the defendant to proffer evidence linking other persons to the crime charged. That's the one I'm referring to.
Okay. Go ahead, Mr. Cruz.
So I address each objection piecemeal.
All right.
So in regards to the Rule 401 objection, which is relevant, the relevance of this line of questioning is just simply to show that a individual that's in custody calling law enforcement and saying, hey, I have information on this case, it isn't something unique to this case. Throughout the history of this case, multiple detectives have spoken with individuals in custody, and they'll call and say, hey, I know who committed this crime, and the information would turn out not to be credible. The specific line of questioning that I was going down with Detective Newton was simply to get to the point that this individual offered information to get leniency, which we believe to the jury would be relevant in determining Mr. Cedric Jeffries' testimony. In regards to Rule 403, and I believe he said waste of time, as well as, if you don't mind, Your Honor, I have waste of time. There was one more that he mentioned.
Confusion of the issues.
Confusion of the
Confusion of the issues.
I'm listening. I'm looking for the motion while you're talking.
Absolutely, that is fine, Your Honor. Do whatever you need to do. In regards to the waste of time, Your Honor, this evidence directly rebuts the state's evidence. They want to present to the jury Mr. Cedric Jeffries as a unique individual that's in custody, and they would like it to appear to the jury that he's the first in custody individual to come forward with tips on this case. This evidence will rebut that image that the state would portray to the jury if Mr. Jeffries is simply allowed to testify. So it isn't a waste of time, Your Honor. And as far as confusion of the issues, I'm not sure of an issue that could be confused by the Honorable Detective Newton simply stating, yes, someone in custody reached out to me 20-something years ago with information on the case. So that would be my proffer in regards to 403, my response in regards to 403. In regards to the Saudi motion, just for purposes of the record, I believe the appropriate term for that is third-party perpetrator or alternative suspect theory under Georgia law. That is not the purpose of this evidence. This individual, if I would have been allowed to go down, or if I'm allowed to go down that question with Honorable Detective Newton, the information turned out not to be credible. So it isn't it wouldn't implicate the alternative party theory or third party perpetrator theory.
Okay, so let me just ask you this question, and Mr. Bolden, I'll let you respond, and I'll let Mr. Cruz respond if you wanted to say something. But given what you've just stated, then why is this testimony relevant?
Absolutely, Your Honor. Thank you for the opportunity to respond to that. So the reason this testimony is relevant is because the state intends to bring in an individual by the name of Mr. Cedric Jeffries, who is an individual that is currently serving a 105-month federal prison sentence.
Right.
The state intends to depict to the jury, which is their right because it's their case that they have the opportunity to present, that Mr. Jeffries is a uniquely situated inmate. So when Mr. Jeffries comes in, he'll testify, hey, I'm in custody, so forth and so on. Mr. Faust admitted this to me, and I'm hoping to get a benefit from the state. The reason this is relevant is because we're showing the jury also that Mr. Jeffries is not uniquely situated. Throughout the history of this case, individuals that are incarcerated have called seeking leniency. Excuse me, let me make that clear for the record. Have called law enforcement offering information in order to receive leniency. So that's the relevance of the question, Your Honor.
Mr. Cruz, who is the person that this witness went and talked to at the jail in Clark County?
So, Your Honor, I did not intend to get into any names. I don't believe the name of the person is relevant.
So it's not Cedric Jeffries.
No, it is not Cedric Jeffries. This is a separate inmate. And I'll say this, Your Honor, I know sometimes I minced up my words, so I may have explained that the wrong way.
Okay.
So in this instance, what I'm saying is that there's a separate individual from years ago when Detective Newton, the Honorable Detective Newton, was working this case. That individual reached out to Detective Newton and said they had information on this case. Okay, that information turned out not to be credible. And that evidence that we're seeking to admit before the jury is to rebut any type of visual or image or piece of evidence that the state may attempt to introduce Mr. Jeffries as an individual that is uniquely situated. And what I mean by that, Your Honor, is Mr. Jeffries is in custody. He's the only person that's ever come forward as someone in custody saying they have information about this case. And his information is, of course, as the jury would learn, is that Mr. Faust confessed to him. Does that make sense? And if I explained it wrong, Your Honor, please forgive me.
Well, I mean, I understand what you're saying,
Yes, ma'am.
the words that you're saying,
Yes, ma'am.
but I still do not understand how this particular testimony is relevant and how it relates to Mr. Jeffries, other than the statement that you just made. And let me know if this is what you meant, other than your statement that the state would produce testimony that said the only person in custody that ever reached out was Mr. Jeffries. Is that what you're saying?
No, I probably used too many words.
Okay.
Credibility, Mr. Jeffries' credibility. That's why this evidence.
How does this testimony that you're seeking to elicit impact Mr. Jeffries' credibility at all?
I think that's an excellent question, Your Honor. So what we intend to show is that multiple individuals that were in custody reached out to law enforcement offering information. Throughout the history of this case, all of that information has turned out to be unreliable. And what we're creating for the jury in regards to Mr. Jeffries' credibility is it's consistent with the information that Mr. Jeffries is providing as well.
Okay, thank you.
Yes, ma'am.
Mr. Bolden, anything else, sir?
Unless the court has any specific questions about the way that I made the objection, I deny.
Okay, I'm making a finding that this information is not relevant.
Yes, ma'am.
And that under 403, it would absolutely lead to confusion of the issues and misleading the jury. I'm not going to allow it. I'm going
Yes,
to
ma'am.
move on.
Yes, ma'am.
Could you bring the jury in, please? All right, y'all may be seated. Thank you. Mr. Cruz?
Yes, ma'am. Thank you, Your Honor. Detective Newton, on May 6, 2001, you spoke with Mr. Chris Melton over the phone. Is that correct?
I don't remember doing that, but I'm sure I spoke with him over the phone several times.
Yes, sir. Would seeing your report refresh your recollection in regards to May 6, 2001?
Yes, sir. Thank you.
Thank you. Let the record reflect that I'm showing the Honorable Detective Newton a copy of his May 6, 2001 report to refresh his recollection.
Yes, sir.
Is your memory refreshed in regards to May 6, 2001?
Yes, sir.
Is it okay if I grab that document?
Yes, sir.
All right, thank you. You don't have to say, sir.
Just have it.
Now, this is May 6, 2001, correct?
Yes, sir.
And when you spoke to, well, you understood that Chris Melton, at the time of this investigation, that Chris Melton was Miss Baker's boyfriend.
Yes, sir.
And I believe it was, he described it as he was her borderline fiance. Is that fair to say?
Yes, sir.
Okay. But when you spoke to him on May 6, 2001, and asked him about the Thursday before his death, he didn't have any memory of it. Is that correct?
If I recall, he didn't have a clear memory of it. I think that would be an accurate way to put it, right? There was a lot of confusion in his mind.
Yes, yes, sir. Thank you for that. There was a discussion about going over Chris Melton's finances. Is that correct?
Yes, sir.
Okay. And were you aware that Chris Melton told law enforcement that he had received a check from a place called Nash Plumbing?
He worked at Nash Plumbing, as I recall from that report.
Excellent.
Yes, sir.
And the bank records would have shown whether or not he worked at Nash Plumbing, correct?
That sounds very logical. Yes, sir.
Okay. But Mr. Melton was not comfortable with you going over his finances, was he?
That is correct.
So based on your time in this investigation, you were never able to confirm whether or not Mr. Melton actually worked for Nash Plumbing.
It's not in that report. I don't recall us doing that, sir.
Okay. Now, during your conversation with Chris, you asked him for the phone number to Nash Plumbing. Do you recall that?
Yes, sir.
And Chris told you he didn't have the number to Nash Plumbing. Is that correct?
That is correct.
Did you find that odd, considering that he said Nash Plumbing was his employer?
I apologize. I don't remember finding it odd or not finding it
Cause
odd.
for speculation, Your Honor.
Overruled.
I don't remember finding it odd or not finding it odd at the time.
You just have an opinion.
But I asked the question. I would assume I would have expected to get an answer.
Yes, sir. Chris Melton also could not provide an exact address for Nash Plumbing, could he?
That is correct.
The only information he could provide is that it is on 78 near Loganville and that it is a hole in the wall. Is that correct?
That is correct.
Do you ever recall going to Nash Plumbing?
I do not recall, sir.
Thank you so much, Honorable Detective Newton. I do not have any other questions for you.
Thank you.
Any redirect, Mr. Bolden?
Your Honor.
May this witness be excused.
Ask that he be excused.
Ms. Cruz, any objection?
I still have him under subpoena, so I would just ask that, and for the witnesses, please forgive me for not bringing this up earlier. Mr. Yalman brought it to my attention. For the witnesses that are under subpoena, just to be respectful of their time, if I can give them 48 hours notice instead of 24 hours notice. Is that okay with the Honorable Court?
I don't have any problem with that. I certainly think that's fair.
Okay, as long as I'm aware, I'll give them 48 hours notice. Thank you.
You're still under subpoena, sir, but you are free to go.
Thank you.
You may call your next witness.
State call Shannon Brown. What's that? No, you didn't say anything about that. Will you raise your right hand, ma'am? You swear affirm testimony you'll give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Okay.
All right. Would you please just state and spell your name for the record?
It's Shannon Brown, SHANNON
And ma'am, where are you currently employed?
at the Athens Clarke County Sheriff's Office.
All right. And what, well, let me ask you this. Does the Athens Clarke County Sheriff's Office keep known photos of individuals from certain times?
We do.
Yes, sir.
I would object. Just one question, Your Honor.
Okay.
In regard, I would object under Rule 4.3. The evidence that the state is attempting to introduce, its probative value is substantially outweighed by its prejudicial impact or undue prejudice. And I also object under Rule 4.4b, OCGA 24-4-4b, as it gets into improper character evidence.
All right, thank you. And anything specific with regard to 403, other than probative value outweighs?
Probative value is outweighed.
That's just, okay. All right, thank you. Mr. Yalman, any response?
Substantially outweighed.
I understood. Thank you.
I think it'd probably be helpful for the court to see the exhibit.
Okay. You know what? We're going to do it again this way. Ladies and gentlemen, I'm going to ask you to go into the jury room. Please don't discuss the case. I think it's best we do it that way, counsel. Y'all may be seated. Thank you. All right, Mr. Yalman, one of the reasons I want to send the jury out is I don't really know what y'all are going to start talking about.
What?
Secondly, could you repeat the question that there was an objection to and just give me more context?
The question, Your Honor, was whether or not the Clarke County Sheriff's Office keeps known pictures of individuals from certain dates and times.
Okay. All right. Thank you. And so you're going to show me the exhibit. You thought that was best for, I need to get a context of what you're
Yes,
asking.
I'm sorry. 112, right?
Yes, 112.
I'm marking State's Exhibit 112, Your Honor.
And then after I take a look at it, if you can respond to Mr. Cruz's objection to 403. Thank you. 412. I'm sorry, 403 and 404B.
And Judge, I just handed the court the exhibit, but for purposes of the record, that would be Mr. Faust's booking photo from early February of 2021, about 2 weeks after the incident. I believe that it is the same or a similar photo to the one that Mr. Cruz showed in openings during his demonstrative aid that he presented to the jury, saying that this was the evidence that he would expect that would come in, showing Mr. Faust's physical appearance, basically as close as we have it to the date of the crime. It is certainly relevant in aiding the jury in making determinations about the accuracy of the sketches done by Ms. Lawson, Ms. Marla Lawson, the GBI sketch artist that did work at the time. I've instructed Ms. Brown, and I think she understands that we're not going to refer to it as a mugshot, a booking photo, make reference to arrest, or anything regarding charges. I'll also note for the court that a stipulation to the admissibility of the photo as being a known image of Mr. Faust from that date and time that it was taken was offered to the defense prior to us beginning evidence in the case. It was discussed with Mr. Cruz again when I offered to stipulate to that yesterday. Did not receive a response. I offered again to stipulate to that this morning and informed Mr. Cruz that this would be our last opportunity opportunity to reach an agreement on a stipulation to the photograph. And he indicated to me that he would give me a response in approximately 5 minutes, and I did not hear again from him about that. So we have Ms. Brown, who's a custodian of records at the Clark County Sheriff's Office, to authenticate the photo. It is certainly relevant, and I believe with the limitations on the way that is referred to. I mean, honestly, Judge, even if you refer to it as a booking photo, I still think that the probative value would be not substantially outweighed by any unfair or undue prejudice of the evidence, but certainly with the limitation of not referring to it as a booking photo or arrest photo or anything along those lines, its probative value is not substantially outweighed by danger of unfair prejudice, confusion of the issues, or any of the other reasons that admission would be barred by 403. It is most certainly relevant. I mean, I think that that's established by both parties by the fact that Mr. Cruz used either that image or a very similar one during his opening statement.
So I do have some questions, and we may have to take a recess for me to do some research. So first of all, even if you don't refer to it, if it is admitted as a booking photo, I mean, there's no question that's what it is. I mean, you can look at it and determine that. So how is that not violative of, at the very least, 404D, at the most attempting to put Mr. Faust's character into issue? So,
well, Judge, it would be violative of 404B if we're seeking to introduce evidence of a previous crime or other act, but we're not actually introducing any evidence of the act that was committed that resulted in Mr. Faust getting arrested on February, I believe, 8th of 2021. We're simply showing that as a known image of Mr. Faust from that time period. If the court is concerned with the background of the image, we have a version in which the background was able to be removed. And so, I mean, this is a version that I could hand to Ms. Brown with the understanding that there wouldn't be an objection to the fact that this image has been altered from the record that was kept by the Clark County Sheriff's Office. We're certainly happy to do that. But I do believe that a known image, even if it is one that is generated as part of an arrest for a different incident than the one that Mr. Faust or any criminal defendant is on trial for, is admissible, especially under these circumstances where we're talking about 25 years later and everyone's appearance has changed substantially. It is especially important to establish Mr. Faust's appearance at the time. If this were a situation where, you know, a year had gone by or 18 months or something along those lines, then you may be in a different position unless there's some kind of special circumstance showing that the defendant's appearance has changed substantially since the time of the crime. But in this case, Judge, just the passage of time has led to a situation where Mr. Faust, Ms. Peavy Hall, Dr. Lowe, basically everybody that's come to testify in this case looks very different than they did at the time of the incident. So that's why it's relevant and necessary.
well, and I understand your relevance argument, and I think you've made an appropriate relevance argument, and I'll certainly let you respond, Mr. Cruz, but so don't worry. But my concern is beyond that. My concern is this line of questioning with this witness and this particular photo. So this one, I'm gonna let you make a response, certainly, Mr. Cruz, but I'm gonna go do some research. So we'll be in recess until I get back. Hopefully it'll be 15 minutes, but I'm gonna give you back your exhibit. If anybody has any case law they want to present the court, they certainly can, but I will be back in hopefully 15 minutes. We'll be in recess. Thank you.
Told us that Mr. Faust did not want to stipulate to anything, and so there would be no stipulations. And then this morning he said, that's a yes from me, but I need to check with him and I'll get you an answer in 5 minutes. And then I never heard anything before we started the evidence in the case. I would state to the court that the offered written stipulation before the start of the trial was that the parties stipulate to the foundation for the admissibility of the defendant's booking photo from February 2001, and that is a fair and accurate depiction of the defendant on the date it was taken. The state shall refrain from making any reference to the image as a booking photograph or otherwise indicating that the photograph is related to illegal acts committed by the defendant. If Mr. Cruz is willing to stipulate to the foundation, I don't need to put it in through a witness from the Clark County Sheriff's Office, and I won't. It would need to be a stipulation that it is both an accurate image of Mr. Faust and it is an image from February 8th of 2001 at 4:33 p.m. I mean, that would be the stipulation. And I'm fine. We've got multiple large copies of it, Your Honor. We're fine doing the front facing only. There's one, I don't even know that Mr. Cruz did this with the image that they used in opening. Obviously, you've seen 112, their cinder blocks. We have one with the background washed out to be white.
You showed me that. I mean, I think that's certainly better than cinder blocks.
Okay.
All right. So let me just say this. I'm going to give you all a couple of minutes to talk about how to go forward with the picture. And here's the reason. Case law is pretty clear that a booking photo in and of itself is not necessarily inadmissible, just based on the fact it's a booking photo. It is dependent on the circumstances upon which it is being asked to be introduced. This particular case, I'm really not even making a comment on whether the photo is admissible or not. That's not really your issue. Your issue is that you're trying to get that photo in through the sheriff's department. And that moment in and of itself creates the implication that is inadmissible, which is that Mr. Faust at some point in the past had been arrested for something. That's the moment that I think the case law is pretty clear is inadmissible. So the photo itself, even a booking photo in the manner that you have suggested, I'm not making a ruling that it is not inadmissible based on Mr. Cruz's objection. What I'm sustaining your objection, Mr. Cruz, but I'm sustaining it because the manner in which the state was trying to introduce it is inadmissible through the sheriff's department. That implication, I think it's pretty clear. The case law is pretty clear. That implication is violative of 403. And so I'm gonna give you all some time to talk about what you can stipulate to. I think the suggestion that both parties have made about that one photo with the background washed out, so to speak, certainly makes sense. The case law is pretty clear that booking photos are typically admissible. It just has to be admitted in the right context. So I'm gonna give you a couple minutes to do that when you're ready.
Ma'am, if you would take an oath, do you swear affirm testimony you'll give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right. If you could, please state and spell your name for the record.
My name is Ann Kistler Rao, ANNEKISLER-RAO.
Come over to this microphone. Ma'am, where are you currently employed?
I'm employed with the Georgia Bureau of Investigation, Division of Forensic Sciences, also known as the State Crime Lab.
How long have you been with the State Crime Lab?
I've been there for 20 years.
And what is your current title and role at the State Crime Lab?
I'm employed as the technical leader of the Trace Evidence Section.
And as far as your educational background, starting with your undergraduate degree, do you mind telling me about what you received your undergraduate degree in?
Yes, I received a degree in biology from the University of Pennsylvania.
Did you receive any other postgraduate degrees?
Yes, I have a master's degree in forensic science from John Jay College.
And once you got to the Georgia Bureau of Investigation, was there any internal training that you went through as part of your GBI employment?
Yes, I've gone through extensive training programs in each of the areas that I am qualified to perform examinations in. So this includes hairs, fibers, glass, paints and polymers, fractured materials.
Okay. And as it relates to hairs, when the GBI receives a hair from law enforcement, wherever that may come from, are there any steps taken to prepare that hair for analysis?
Yes, typically we will mount hairs on microscope slides. So we'll take a microscope slide, put the hair on it with some mounting media, and then put a cover slip on top to hold that hair in place and use it for further examination.
All right. And let me ask you this. Once your examination is done with a piece of hair, is the typical practice to remove that from the mount and place it back in an envelope to go back to the law enforcement agency?
No, typically we will then package those slides in a slide holder and then we'll put it in a package and preserve it that way.
Okay. So back in February of 2024, so about 2 years ago now, were you working at the GBI at that point?
Yes, I was.
All right. And did you're not you personally, but did the Georgia Bureau of Investigation's Crime Lab receive communication from Agent Elizabeth Bigham?
Yes.
Okay. And what was that related to?
This was related to a box of slides. It was determined that we needed to look at the box of slides to inventory what was present within that box.
All right. And did somebody at the crime lab look at those slides to conduct that inventory?
Yes.
All right. Who was that person?
One of our lab techs within the trace evidence section, Valencia Johnson.
What was discovered upon the inventory?
Upon inventory, it was discovered that some of these slides were broken.
Okay. And so let me ask you a question about ways that things were packaged back in 2001 or the early 2000s as compared to the way things are packaged now. Okay. How were slides packaged back in the early 2000s?
They might be packaged in various ways, but one of the ways would be to just wrap it in paper towels, or it might be otherwise packaged. Since then, we have acquired plastic slide boxes that are a little more sturdy that can prevent further damage.
And so you mentioned preventing further damage. Have there been situations where the slide in the old way of packaging things, not without the slide boxes you're talking about, gets damaged?
Yes, that's possible.
Okay. In this particular case, after the inventory was done, was there any damage to the slides?
Yes, some of the slides within the box did have some damage.
Okay. And so when a slide is damaged, what are your options at that point regarding remedying the damage?
It depends on if further examination is going to be done with that slide. So if it was damaged enough so the cover slip was cracked and we couldn't really see anything, then we might have to remount those hairs on a new slide. But if we were just preserving the slide to prevent further damage, like in this case, we just use tape on a lot of the slides to just tape it together to make sure nothing further happened to the slide.
Okay. And were you involved in that process?
Yes.
Okay. Were you the only person involved in that process?
No, 2 other hair examiners were also involved.
In the slides that were related to this case, was there any damage noted that compromised the hairs that had been mounted to the slides?
No, there was no note of damage that compromised any hairs.
All right. I'm going to hand you about 9 different plastic boxes here. So bear with me as we label these and show them to opposing counsel first. And ma'am, is it last name referred to as Ms. Kistler Rao?
Yes.
All right. Ms. Kistler Rao, I'm going to hand you state exhibits 114, 115, 116, and 117. The exhibit stickers are on the front, there's other workings on the back. Will you look through those and then just let me know when you've had a chance to review all of that?
Okay.
And do you recognize State's Exhibit 114?
Yes, I do.
Okay. And how is it that you recognize State's Exhibit 114?
It has a label on the cover that I wrote with the unique case number and item number on it.
Okay. And so were the case number or item number, would that have been altered at the time that y'all repackaged it or noted in your records in a different way?
No, so it would be the same case number that it originally had. So the slides were originally marked with a case number on them. So we just copied the case number onto the outer container so we would know what's inside that box.
And does that appear to be in the same condition as when y'all repackaged it or repaired it at the GBI?
Yes.
I moved to tender 114 at this time, Your Honor.
Any objection?
Yes, ma'am. I would ask that the state establish an appropriate chain of custody for those 3 slides, Your Honor. I'm sorry. Please go ahead. I do have an objection, Your Honor.
Go ahead.
My objection is I would ask that the state establish an appropriate chain of custody for those items under 221 Georgia Appeal 472 Southeast 2nd 461, and the case is Harper v. Dooley. And I'll just ask that the state meets its burden, showing the chain of custody before the honorable court admits its evidence.
All right, thank you. Mr. Yellenchely, any response to the objection?
Your Honor, I believe what will be borne out is that these are the slides, as Ms. Kistler-Rao has testified to, that were part of that DOFS case number, and that these particular slides are the same hairs that Dr. Faust submitted as part of the recovery in the autopsy.
All right, thank you. Yes, sir.
If he can establish that chain of custody, that's our objection.
All right, well, in terms of the objection about admissibility, the state has anything else?
No, I was just
Yeah.
listening. I'm sorry.
Okay. In terms of the objection about admissibility, the state has laid a foundation that is appropriate under the law, and so I'm going to admit them over objection at this point. Certainly, if you all want to argue other things with regard to the admitted evidence, you can. But in terms of the foundation that has been laid by the state, simply for its admissibility at this stage, I'm going to overrule your objection. You may continue.
Yes, Your Honor. As it relates to State's Exhibit 114, are you able to determine where the lab received those hairs from, or the trace evidence section, I guess?
May I refer to my notes?
Lack of personal knowledge, Your Honor.
Mr. Yellenchely, any response to the objection?
I think that this witness, in reference to her notes about where the items were obtained from in the crime lab in conjunction with Dr. Falzon's testimony, lays the foundation for that.
Yes, sir.
I may have misunderstood his question. I thought he was asking that based on those items themselves, that you tell where they came from. The reason I lodged the hearsay objection is because I took it as, and you correct me if I'm wrong, that she was simply going to read someone else's writing to determine where those items came from. But if she has it in her personal knowledge, the objection is irrelevant.
Okay.
She has to look at somebody else's words to determine. That's what we're lodging our objection.
Is your objection, Mr. Cruz, personal knowledge or hearsay or both?
So it would try to be both if she doesn't have personal knowledge.
All right. I'm going to let you ask the question again, Mr. Yellenchely. If you want to object, Mr. Cruz, I'll hear it. But go ahead and ask the question again, sir.
What is State's number 114? What is that noted as in your notes about what the item is?
It was identified as collected from the victim's left hand and the victim's buttocks.
Okay. State's Exhibit 115, do you recognize that item?
Yes.
Okay. And how do you recognize 115?
This also has a label on it with our unique case and item number and that I did.
And where is it's Exhibit 115? Where is that item noted as being recovered from?
It is identified as recovered from the torso.
Okay. And is that in substantially the same condition as it was when you repackaged it?
Yes.
Okay. State's move to tender 115, Judge.
Any objection, Mr. Cruz?
Outside our chain of custody, no, ma'am.
All right. I'm going to admit it.
And State's Exhibit 116, do you recognize what that is?
Yes, I do.
Okay. How do you recognize that?
This also has our unique case number and item number on the outside of the box.
And where is that item identified as being recovered from?
This is identified as from the victim's left hand.
And does that appear to be in substantially the same condition it was when you all repackaged it?
Yes.
Move to tender 116 at this time, Your Honor.
Any objection, Mr. Cruz?
Other than our chain of custody objection, no, ma'am.
Okay, I'm going to admit it.
State's Exhibit 117, do you recognize that item?
Yes.
How do you recognize that item?
This item also has our unique crime case number and item number on the outside of the package.
And where is 117 identified as having been collected from?
This is identified as from the torso and from a towel.
And is that in substantially the same condition it was when you all repackaged it?
Yes.
Judge, I move to tender 117 at this time.
Any objection, Mr. Cruz?
Yes, ma'am. Save court time. I'll just say to all the ones we've mentioned chain of custody to, I'll just mention that now, but furthermore, no.
All right. Thank you. It is admitted. Go ahead, sir.
I'll retrieve those. And Ms. Kistler-Rao, I'm going to hand you State's Exhibits 118 through 123. As it relates to State's Exhibit 118, do you recognize that item?
Yes, I do.
How do you recognize that item?
This item has our unique crime lab case number and item numbers on a label on the outside of the box.
Where is that item identified as having been collected from?
This item is identified as containing the known pubic hair of James Barker and the known pubic hair of Chris Melton.
And does that appear to be in substantially the same condition as it was when you repackaged it?
Yes.
Judge, I move to tender 118 at this time.
Any objection?
No objection, Your Honor.
It is admitted.
Going forward to State's Exhibit 119, do you recognize that item?
Yes, I do.
And what do you recognize, or how do you recognize that item?
This item also has the unique crime lab case number and item number on a label on the outside.
And where is that item identified as having been collected from?
This item is identified as being known head hair of Chris Melton and known head hair of Christopher Hall.
All right. And does that appear to be in substantially the same condition it was when you repackaged it?
Yes.
Judge, I'd move to tender 119.
Any objection, Mr. Cruz? It is admitted.
State's Exhibit 120, do you recognize that item?
Yes, I do.
How do you recognize that item?
This item also has our unique crime lab case number and item number on a label on the outside.
What is it and where is it identified as having been collected from?
This is identified as the known head hair of Ashley PV.
Does that appear to be in substantially the same condition as it was when y'all repackaged it?
Yes.
I move to tender 120 at this time.
Any objection, Mr. Cruz? It is admitted.
As it relates to State's Exhibit 121, do you recognize that item?
Yes, I do.
How do you recognize it?
This item also has our unique crime lab case number and item numbers on a label on the outside.
What is it and where is it identified as having been collected from?
This is identified as being known head hair and known pubic hair of Valerie Lang.
And does that appear to be in substantially the same condition as when it was repackaged or repaired by the GBI?
Yes.
Judge, I move to tender 121.
Mr. Cruz, any objection? It is admitted.
State's Exhibit 122, ma'am. Do you recognize that item?
Yes, I do.
How do you recognize it?
This item also has our unique crime lab case number and item numbers on a label on the outside.
And what is it and where is it identified as having been collected from?
This is identified as being known head hair of Valerie Lang and known head hair of Ashley PV.
And is it in substantially the same condition as it was when it was repackaged by the GBI?
Yes.
Judge, I move to tender 122.
Any objection, Mr. Cruz? It is admitted.
State's Exhibit 123. Do you recognize that item?
Yes, I do.
How do you recognize that item?
This item also has our unique crime lab case number and item number on the outside of the box.
And what is it and where is it identified as having been collected from?
This item is identified as being known head hair of Valerie Lang.
And does it appear to be in substantially the same condition as it was when it was repackaged by the GBI?
Yes, it does.
Judge, I move to tender 123 at this time.
Any objection, Mr. Cruz? It is admitted.
Ms. Kissler-Rao, thank you very much, ma'am. That's all the questions I have for you right now.
Mr. Cruz, cross-examination.
Do we have a bicycle large?
Well.
Medium to extra large. So, okay.
In course indulgence, Your Honor.
Here are some of them.
My name is Ahmad Cruz. I have the privilege and honor of representing Mr. Edric Faust. Is it okay if I ask you a couple of questions? I want to make sure I pronounce your name properly. May I have your last name, please?
Kissler-Rao.
Ms. Kissler-Rao?
Yes.
Perfect. Do you have the slides with you?
I have some of the slides still up here.
Is it okay if I approach them?
Yes.
Approach and grab them? Ms. Kissler-Rao, you'd agree that the state asked you questions about these hairs here.
Yes.
Is that correct? Now, the hairs that the state asked you about weren't the only hairs collected. Is that correct?
I'm not aware.
Are you aware of a hair being retrieved from a power transformer in this case?
I'm not aware of that.
And are you the individual that packaged these hairs?
It was me along with two other hair examiners.
Which ones did you package?
I can tell you which labels are the ones I made.
Please.
I would need to see them.
So let me slide these back in. Of course, indulgence to figure out which hair is which. I'm just looking for a particular slide, if that's okay. And thank you so much for your patience. And these are the conditions. Let me rephrase the question. This isn't the condition that you put these slides, package these slides up as, are they?
So we took the slides, put them in the slide boxes, and then packaged them.
In this condition with the slides broken?
I'd have to see it a little closer, but it's possible, yes. So no, it's fine. So the slide is a little bit broken, but it's still intact. So I'm not sure if it.
Are there any policies in regards to safekeeping evidence in a criminal case?
What types of policies are you referring to?
Sure. Quality assurance policies, retention policies, storage policies to ensure that items aren't damaged.
So again, when we are done with an examination, we will package the items away into a sealed, secured container.
And your testimony is that you are not aware of any other hairs missing from these containers.
I'm not aware of it.
Sure. You have your report with you?
I did not issue a report for this particular.
Well, Ms. Kistler-Rao, during direct, you said you were using your report to refer to the hairs.
No, I was using my notes to refer to the hairs.
So you didn't issue a report on any, and if I phrase it wrong, please correct me, but you didn't issue a report to the work you did prepping these hairs?
So I did not prep these hairs. It was just opened and inventoried, and then we might have taped some of these slides, repaired anything to preserve it for future efforts. So no actual analysis was done at the time.
I may have asked this question wrong.
I'm sorry. We've got a lot of these boxes open. A lot of people are handling them. I just want to make sure all the slides go back in the boxes that they were taken out of. So if we could do it in a way in which we're talking about one box or opening one box at a time, I think that is the best way to do it. I'm sorry. I know that's not a legal objection. It's just, I think it's something that might be important.
Well, and I guess we didn't talk about publishing it to the jury. They are in evidence, but we need to talk about, are you trying to publish all of the slides to the jury?
The relevant slides to the jury, Your Honor.
I'm happy to put that on the record, which slides you want to publish to the jury.
And once I get,
I think, Your Honor, the jury something needs to be passed to the court, maybe through the bailiff or from a jurist, but they're trying to address the court about something here.
Thank you. Thank you for that. All right. Yes, sir.
Can we display these on the Elmo, please? I understand there's some latitude about how to do it, but this is not a good way to do this.
I think that would be best. Mr. Cruz, I'm going to ask you to retrieve that
Yes, ma'am.
piece of evidence.
I can do that.
Judge, I'm sorry, we may need to send the jury out so that we can see what fell, what we can recover, and what we can't recover.
Sure.
I will use the elbow.
All right, well, Mr. Yonachilli would like to make sure that we have recovered everything. So I think probably that's the best way to handle this moment. Ladies and gentlemen, I'll have you go into the jury room. It's a good time for a restroom break. And please don't talk about the case. I'll bring you out as soon as we can put things back together.
Yeah, do you want some gloves?
Yes.
Number 12. Okay. This is our case number. So the case number. When we go to the chain of custody report, and this is listed as Q hair recovered from debris with power module. First, Your Honor, that isn't listed anywhere in the chain of custody report. But when you go to item number 12 on the chain of custody report, item number 12 is identified as sealed package, identified as containing power transformer. These are two different items, Your Honor.
Let me just interrupt you for one moment, Mr. Cruz, and ask you this question about a chain of custody motion.
Yes,
What is it ultimately you're asking the court to do with regard to your issue, whatever it is, with the, as you articulate, lack of a proper chain of custody? What are you asking the court to do?
We raised the issue. The state elicited testimony regarding these items and the proper packaging of these
I know,
items.
but what are you
So
asking
the
me?
very first thing I'm asking, Your Honor, is to determine whether chain of custody is proper. If chain of custody is not proper, Your Honor, we're going to move for a mistrial. But I think we should flesh out the threshold issue. And, Your Honor, I respect the utmost respect. Even if the court decides to deny the motion, we may still move for a mistrial. A significant number of these hairs, if I'm understanding the labeling properly, are mislabeled. Now, I can stand to be corrected. The state can show me something that may be completely different. But I would ask to have opportunity to flesh this out on the record, if I may.
Mr. Yamacho, you care to respond to the motion, even though we haven't gone into full detail, about a lack of chain of custody and issues related to that in terms of a.
I can try, Judge. Here, I'll step to the microphone.
Okay.
I guess one, there's been no identification of what exhibit it is that Mr. Cruz is talking about. I believe to the extent that a chain of custody challenge is made, and I'd have to look at the cases, Your Honor, but I do believe reading something about needing to make an affirmative showing of tampering, at least some type of evidentiary showing of that. But again, that's just off the top of my head when you're thinking about litigating chain of custody issues. As far as the chain of custody in this case, with both Lieutenant Liedall as well as Dr. Falzon, I believe, as well as Mr. Newton, who testified about the collection of known hairs as well, Your Honor, I think that the state has met its obligation thus far in chain of custody, and with the caveat that Mr. Peterson is expected to testify for the state as well. The extent of his testimony will be determined by the court's ruling in the Daubert motion, but at a minimum, he would testify for purposes of establishing another link of that chain of custody. I also believe, at least, that there's case law indicating that when you have an investigative agency or an agency like the GBI, essentially the entire agency is considered for chain of custody purposes. But again, Your Honor, I'm not citing these as holdings. I do believe that that general principle is correct, though, but certainly could look into the issue further if the court instructs us to do so.
All right, thank you. So, Mr. Cruz, are you asking the court to not allow certain evidence in based on a chain of custody argument? Is that what you're asking?
So, Your Honor, that's what I was asking originally when we made the initial motion, just that the state lay a foundation for the chain of custody. Now I'm asking to flesh out, if the Honorable Court will allow, to flesh out the record in regards to chain of custody with the Honorable Court. And probably the way the hearing goes, Your Honor, unless I am mistaken, I can be. I don't want to stand in my place and say I'm certain I can be, but the burden is on the state to establish a chain of custody. If I am not mistaken, if there are errors with the chain of custody based on how far we've gotten in this testimony, and not just about things we discussed in this trial, including the envelopes, I would be moving forward at that time. But I'd like to flesh out the issue a little bit further on the record first, if that is okay.
Okay, so the answer to your question is no.
Yes, ma'am.
And I don't really know what your motion is with regard to chain of custody, but I will just say this. The chain of custody, if you choose to challenge the chain of custody, certainly you have the right to do that if you decide that that's appropriate for your case. What you are referring to is the weight of the evidence rather than the admissibility of the evidence. And it is not... I'm just going to deny your motion on chain of custody. You can challenge it however you choose, but this is not a moment where the court has where the court is in a position to exclude evidence based on your argument that chain of custody has been established or hasn't been established. And that is an argument you certainly can make however you choose to do it. You can always make that challenge, but what you're asking the court is not something the court needs to make a ruling on in the manner that you have asked it to. So I'm going to deny the motion as best I understand it about chain of custody, and we're going to continue cross-examination. The court's question for all counsel is, where are we with the evidence that was on the floor or not on the floor, or did we sort that out?
Yes, Judge.
Okay.
One of the slides broke. However, it's my understanding that the mounting did not come apart.
Okay.
The evidence was not lost. Ms. Kistler-Rao, I think, was able to put things back together, and it was placed back in the plastic slide box.
Outstanding. Okay, so we're going to bring the jury back in. You may continue your cross-examination, and I think it is best at this point, Mr. Cruz, if you want to publish to the jury, to use the, well, I'll call it an overhead projector, but that is not what it is. We're going to use that. And then if the jury needs to handle any of the slides during deliberations, I think we need to talk about how to make that happen. Maybe bring them out, do it in more of a supervised fashion, things of that nature. All right, would you bring the jury in, please? Thank you. All right, y'all may be seated. Thank you. We're back on the record. Thank you for your patience, ladies and gentlemen. And Mr. Cruz, cross-examination.
Ms. Kistler-Rao, you would agree that the GBI has a policy for the preservation of evidence. Is that correct?
Yes, that's correct.
And the purposes of such a policy is to prevent evidence from being lost, damaged, mixed up, things of that nature. Is that correct?
Yes, as long as it's in our custody, we want to keep it secure, and then when we return it to the agency, we send it in a secured package.
Okay, thank you. I'd like to show you, I believe, a slide that you mentioned with the state that you repackaged. Can you identify this slide? Is that one of the slides that you repackaged, or would that have been one of the other two individuals?
I don't know who repackaged it. We all worked together at the same time, so I don't know which particular individual put that in the package.
Sure, but this, I'm assuming it was an agreement that it was okay to put this in the packaging in this condition?
Yes, it's intact and was able to be put in a slide box.
Sure. What year did this take place where you started going through the boxes with the two other individuals?
That was in 2024.
So it's recent. Okay. Do you know that these hairs were collected in 2001?
Yes.
Do you know whether the hairs that are contained in these items are the actual hairs that were collected?
So I have no direct knowledge of the mounting of the hairs. The only knowledge I have is of the slides we received. Everything, we repaired what we could and put it back in a package.
You stated repair what you could. What about the things that you could not repair?
Again, we repaired them to the point where we felt that they were secure in their package.
Were these slides relabeled in 2024?
No, I don't believe so.
And I could have heard you wrong. I thought you mentioned during direct examination that you relabeled, or you labeled some of these slides.
I was referring to the slide boxes. So the label on the outside of the box that told you what was inside that box. Those are the labels that we created.
That would be that item there.
That's correct. Yes.
Can you tell the jury the preservation policy of the GBI when it comes to evidence collected on an open on an open case?
Again, like our preservation is that we will place evidence in sealed packages. We seal them with evidence tape. That's secure to secure them.
So to make sure I understand the entirety of the GBI policy and the preservation of evidence, you put it in sealed packages and secure with evidence tape?
That's correct.
Is this considered a sealed package?
Those slides were placed in a larger slide box, and that slide box was sealed with evidence tape.
And were you the individual that sealed that box?
I don't believe I was the one who did the final sealing of the box.
I'd like to show you a couple of these slides. You let me know if this was part of the repackaging that you all were doing. And was it this difficult to get the slides inside of the box?
Sometimes it can be, yes.
Does that raise concerns about the slides being potentially damaged or breaking?
No, as long as they're in the box, it should provide at least better security for them than the former method of wrapping them in paper towels.
What I'm asking about particularly is putting the slides inside of the box. There are no concerns about these slides breaking?
I have yet to have an issue with slides breaking when I put them in the box.
Of course, no.
I don't. Do you want to give it to But if you're having trouble putting it back in, choose one.
I'd like you to put these slides in the box for the jury. Is it okay if I approach you?
Sure.
Would you like some gloves?
No, that's okay. So one of the slides was just misplaced and it's no longer, I have to take 2 of them out because it's no longer in order. Okay. All right, now it's back in the box.
This slide here is one of the slides that that was found in that box. Not that one there, I'm sorry. This one isn't labeled. Your Honor, I'd like to show the witness what I'm marking as defense exhibit 31. Let the record reflect that I'm showing the witness. Let the record reflect that I'm showing the witness what has been marked as defense exhibit 31. And take your time to look at defense exhibit 31. If you would like, you can take the slides out just to review the slides. I'd like to also show you State's Exhibit. Well, before I show you State's Exhibit 114, do you recognize Defense Exhibit 31?
Yes, this item also has labels with our unique case number and item numbers of the slides that it contains.
And I want to make sure I pronounce it correctly. Can I call this a container?
Yes,
The container that the slides are in, you recognize the container, right?
yes,
And the slides that are within that container.
yes,
And are those slides in the container, excuse me, have the slides in the container been altered in any way to your knowledge?
not to my knowledge.
Okay. And is that a fair and accurate package of slides as you remember those slides?
As far as I know, yes.
Your Honor, I would move to admit Defense Exhibit 31 as evidence.
Any objection, Mr. Limoncelli?
No objection, Your Honor.
It's admitted.
May I approach the witness, Your Honor?
You may.
You gave us a qualifier. You said not to my knowledge. Can you explain that? When I asked you, have these slides been altered in any way?
They don't appear to have been altered by me.
Of course, you know this particular slide. I asked you this. The state didn't ask you to introduce Defense Exhibit 31, did they?
No.
In Defense Exhibit 31, there's a hair in this item that is labeled hair from the power transformer. Is that correct?
Yes, that is what the box indicates, and yes.
And just, you didn't do any testing? I want to be clear on that?
Not on these particular items.
Yeah, that is fair. But the hair that's from the power transformer is a fair and accurate depiction of what you remember packaging up in this device.
Yeah, that's what it was identified as with its label, yes.
And just so we don't confuse the issue with the jury, the hair from the drain assembly is different from the hair that would be on the power transformer that was found, correct?
You know, well, I might misunderstand the question a little bit. I'd object if it's calling for some kind of comparison between the hairs, as Ms. Kistler-Rao has testified that she didn't do any analysis. If Mr. Cruz is just saying that the two slides are different slides, then I don't have an objection. I'm just not clear entirely what the question was eliciting.
All right, Mr. Cruz, any response?
Was for comparison as far as her looking at the slide, both slides.
I'm going to object, then, Your Honor. If he's asked, he already asked, and the witness said she had not conducted any analysis.
All right, any response to the objection?
No, ma'am, I stand by my response. Your Honor.
Okay, I'm going to sustain the objection.
Yes, ma'am. In this sense, slide-wise, because both of these will be into evidence, I could get it out. And actually, can you help me with this, Mr.
Try. Okay, which one? Oh, yes. Oh, gosh. Almost.
There we go.
I'd like to show you a slide that is labeled as hair number 12 from cord of power transformer. You see the hair there, Ms. Rao? Kisler Rao?
Yes, yes, I do.
I'd like to also show you my last question for you. This hair is a part of Defense Exhibit 31. Is that correct?
Yes.
Thank you. And I have no other questions for this witness, but I may need this witness's help putting these slides back in, Your Honor, so please forgive me.
All right. Mr. Almond-Chile, any redirect of this witness?
I do.
All right, go ahead, sir.
Yeah. Oh, it's fine. You want to just take it up? I can wait until you're done.
If you want to get that assistance now, you certainly can, and we can wait. That's fine. Yeah. Go ahead, sir.
Thank you, Your Honor. Let me show Mr. Cruz what I've marked as State's Exhibits 124 and 125. And Ms. Kissler, I'm going to hand you States 124 and 125. Starting with States 124, do you recognize that item?
Yes.
How do you recognize it?
This item has our crime lab case number and the item number that the slides came from on the package.
What's located in 124 and where does it indicate that it was recovered from?
This is identified as the known head hair and known pubic hair of Ashley Peavy.
And does that appear to be in substantially the same condition as when it was repackaged by the GBI?
Yes, it does.
And Judge, I move to tender 124.
Any objection? It is admitted.
And then as to State's Exhibit 125, what is 125?
125 is identified as the known head hair and known pubic hair of Tara Baker.
And how do you recognize that?
It also has our unique crime lab case number and the item number that the slides came from.
Does that appear to be in substantially the same condition as when it was repackaged by the GBI?
Yes, it does.
And I move to tender 125 at this time, Judge.
Any objection, Mr. Cruz? It is admitted.
And then Mr. Cruz asked you a question about what year it was when these items were repackaged. I think he testified to this earlier. What month and year was it when they were repackaged?
It was February of 2024.
Okay. I don't think I have any other questions for you right now, Ms. Kissler-Rao.
Any recross, Mr. Cruz?
No, ma'am, no response.
May this witness be excused, Mr. Almond-Chile?
We'd ask that she is, Judge.
Any objection from the defense? You are free to go. You may call your next witness.
State calls David Griffith.
Could you get David Griffith, please?
Okay, I'm gonna pause for a minute and we're gonna take a music break. We have, oh gosh. We have 2 more witnesses today. Okay, so I think it'll be about an hour and a half more, but I want to push through and get it done because the fundraiser is Friday, so I want to get as much done of the trial as we can before that happens. All right, let's go with this one. I'll be right back, y'all.
From Boston fog to courthouse stone, Aiden wore the truth like a coat. He dug through lies and copied files till the whole damn paper started to glow. He found the name of Officer John, found the edits, found the bloodless lines, found the hands that scrubbed the page and the grin they wore when they sold that lie. They said, let it sleep. They said, walk away, but Aiden kept the receipts in a drawer that shook all day. Never poke a turtle, never poke a turtle. Slow step, hard shell, truth crawls, but it hits like hell. Never poke a turtle, never poke a turtle. Commonwealth came with polished words and suits that fit a guilty frame. They leaned on names, they bent the facts, tried to bury John, then bury the blame. Aiden stood in the floodlit hall with his notes and a jaw like iron. He said, if you want this dead and gone, you'll have to kill every page I'm on. They locked the door, they raised the heat, but every thread they poured only sharpened what he'd see. Never poke a turtle, never poke a turtle. Slow step, hard shell, truth crawls, but it hits like hell. Never poke a turtle, never poke a turtle. You can hide for a while, but you can't hide forever. And late came the lesson, too late for their hand. What moves in the dark still leaves marks in the sand. Aiden from Boston still stands in the rain. One man, one story, and a city saying names. Never poke a turtle, never poke a turtle. Slow step, hard shell, truth crawls, but it hits like hell. Never poke a turtle, never poke a turtle. You can hide for a while, but you can't hide forever.
Sir, will you raise your right hand and take an oath? Do you swear a firm testimony you'll give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? If you would, please state and spell your name for the record.
My name is David Griffith, DAVID-GRIFFETH.
And sir, what do you currently do for work?
I'm a technology consultant. I primarily manage public safety information technology stacks.
Okay. Before you did that, did you ever work for the Athens Clarke County Police Department?
I did.
How long did you work for ACCPD?
I worked for ACCPD for just under 15 years, from November of 2004 until October of 2019.
Okay. And what was your title when you were with ACCPD?
I was a criminal analyst.
All right. Let's back up a little bit. And what did you study when you were in college?
Finance at the University of Georgia.
All right. Did you take a little break before you received your degree?
I did. I was in school at UGA from 89 to 93. During that time, I started a software company. And my senior year of college, I left school to pursue that software company, sold the assets of that company in 2003, and went back and finished my last couple of classes to obtain the finance degree.
Yeah. Well, I just found this out now, but I think we were at UGA at the same time. I was a freshman and when you went back. But so that software company, after you sold the assets of it, went back and got your degree, what were you doing after that?
I didn't really know what I was going to do. I just by chance ended up attending the Citizens Police Academy. I guess let me back up a little bit. I was in a church group. I made some offhanded comments about police officers to a buddy of mine that was a police officer in Athens, Clarke County. and he challenged my assumptions about law enforcement in the community and said I should attend the Citizens Police Academy. So I did. The Citizens Police Academy at the time, and I guess it probably still is, was a kind of a public outreach effort to bridge the gap between the community and law enforcement. And it was I think it was a 12-week course. One night a week you would go, and some aspect of the department was presented to you, and you would get to see the inside operations of the agency. During that Citizens Police Academy, the command staff asked me to apply for a position at the agency that they had open. It was the crime analyst position. And I thought, well, I'll apply. And they offered me a job. And I thought, well, maybe I'll do this for a couple of years. And a couple of years turned into 15 years.
Initially, when they brought you on, was your technology background an attraction to them?
It was. The chief at the time, Jack Lumpkin, was looking to modernize the police department's technology stacks. And so I could offer some expertise in that area.
The crime analyst field in general in law enforcement, kind of what stage of its development was it in when you started with ACCPD?
It was a very new position that a lot of agencies did not have at the time. Athens was kind of on the cutting edge. The best way to describe it was a specialized unit that was trying to figure out its way in law enforcement and what role it would play at the time.
In your work as a crime analyst, were you ever involved in any trainings?
I was. Over the course of 15 years, I had hundreds of hours of training as it relates to this trial. I was trained in all facets of intelligence analysts through the years, but specifically cold case homicide training. At the time I was hired in 2004, this case had languished a little bit, and they sent me to cold case training at GBI headquarters. It was a cold case training put on by DHS and FLETC. That was a 40-hour course, and they also sent me to the FBI Academy in Quantico, Virginia, to do cold case training there. That was another 48-hour homicide training course.
Okay.
And in addition to that, I think I went to Brunswick, Georgia, and did 40 hours of training with an NCIS.
Okay. And so those are the trainings that you attended. Did you ever conduct trainings for any other crime analysts?
I did. Sometime shortly after the GBI training, FLETC approached me and asked if I would be an adjunct instructor for FLETC. FLETC is the Federal Law Enforcement Training Center down in, they've got multiple campuses, but the main campus is in Brunswick, Georgia. They train federal law enforcement across the nation. And so from 2007 to 2011, I was an adjunct instructor for FLETC and helped develop curriculum to train analysts across the nation.
At any time during your career with the Athens Clarke County Police Department, were you assigned as a crime analyst to work on the murder of Tara Baker?
I was.
Okay. And if you recall, it's been a while, when do you think you first had contact with the case file?
Sometime in late 2005. I've got a very vivid memory of meeting the Baker family at the arch on the 5th anniversary of Tara's death. So I know that in January of 2006, I was actively working on it.
Okay. Well, was there a detective at the Athens Clarke County Police Department that when you first got the case file, you were working on it with in conjunction?
There were two, Sean Potter and Courtney Gale.
Okay. And can you describe for the jury how crime analysts work in conjunction with detectives? What's your role in that relationship?
So we were a support unit and that brought a specialized skill set to help analyze the case file. Our role was to help, at that time, the case file was very large. So multiple volumes of statements, supplementals, evidence. It would have been thousands of pages at that point. So my role was to to review the case file, make an assessment of where we were, what avenues we might explore going forward, and give a broad overview synopsis of the case.
And so what kind of organizational condition was the case file in when you picked it up for the first time, or I guess we're assigned to it for the first time? I'm not sure you could pick the whole thing up.
No, you couldn't pick it up. It was literally multiple volumes locked away in the Criminal Investigations Division at the police department. So the case file at that time was what I would call analog. It was literally paper reports assembled in 3-ring binders. It was in good order. Lots of care had been taken to keep it in good order through the years. At that point, lots of investigators had worked on the case. My role was probably something like attorneys would get ready for a trial in court. I wanted to assemble a timeline of events so that we were sure we understood. Let me back up a little bit. When you've got a homicide investigation going on, this case had dozens of active investigators in the days immediately following the crime. There were investigators from the Athens Clarke County Police Department, the University of Georgia Police Department, the Georgia Bureau of Investigation. They were all working collectively to gather information and put together this case file. So what happens is those agents and case investigators go out and conduct interviews, collect evidence, and they write reports about what they've discovered or found or collected, and they're assembled in this case file. So my role was to go through that case file and to assemble a common book of facts, chronology. The software that we used to help assemble that knowledge was called Case Map. It's probably still used today. So that software labeled things like a cast of characters. That would be the subjects that were part of the investigation, the witnesses, the persons of interest, the victims, the facts of the case, so the dates and times, the events that happened, the evidence that was involved in the case, so the trace evidence collected at the scene, all the evidence that you're going to talk about during the course of this trial.
At any point, did an opportunity come up to discuss this case with other law enforcement professionals?
On many occasions.
Right. That was an imprecise question. I'll try again. Did any of those occasions involve the Federal Bureau of Investigation?
Yes.
Okay. And so can you tell me what that event was?
So at some point in 2006, one of the avenues that we pursued was we submitted the Tara Baker case to the FBI's violent criminal apprehension program. What that entails is we prepared a synopsis of what we knew about the crime and what had occurred and what we knew about the victim and the offender, and we transmitted that information to the specialized unit at the FBI. The FBI, after receiving that report, asked the agency to come present the case file for peer review in Quantico, Virginia. That was sometime in 2006.
Did you take advantage of that opportunity?
We did. Myself, Sergeant Courtney Gale, who was with the Athens Clark County Police Department, Jesse Maddox, who was a GBI agent. I believe he's probably the SAC in Athens at this time. Monica Bumgarner, who's also a GBI agent. She now works for the ATF. We traveled to Virginia to present the case.
Can you describe, what does that mean or look like to present the case at the FBI Cold Case Symposium?
I can. We were one of, I believe it was 8 agencies that presented cases. So basically, the investigators and analysts from these agencies come together and present their cold case in a roundtable type form. So we all sat around and discussed our cases, made a formal presentation, and then collectively we talked about what each agency could do to further its investigation of the case.
Okay. In preparation for that, what's the depth of, I guess, information and knowledge about the case that you're presenting that's necessary to be able to present at a symposium like that?
The expectation is that you'll be able to present every aspect of the case that's important to the investigation. So you would need to know the case from beginning to end, all the facts, all the chronology, all the people involved.
And obviously, I think you said that was, you believe, sometime in 2006. It's been, depending when in 2006, 19 or 20 years since then. Has your memory faded a little bit since then?
Oh, yeah. I probably have forgotten more than I recall about this case after 20 plus years of working on it.
It's a pretty large file.
It is.
Well, let me ask you this. Do you recall the name Chris Melton?
I do recall the name Chris Melton.
Okay. So did ACCPD investigate Mr. Melton after this crime occurred?
We did.
And did you have an opportunity to review that investigation?
Yes.
Okay. At any point, did Mr. Melton become, in your estimation as a crime analyst and being part of the continued investigation for a number of years, no longer a viable suspect in ACCPD's mind?
Chris Melton, of course, was a person of interest from the very beginning. If you looked at homicides in aggregate across the nation, more often than not, the offender in a homicide's known to the victim, and often it's somebody that's close to the victim, a significant other, boyfriend, spouse. So Chris Melton was a person of interest for the agency, very much so. The agency went to great lengths, I guess colloquially in the inner workings of the agency, that the investigators would say, we're trying to either put this person in or put them out of the case as a suspect. I don't know that anybody would say Chris Melton was absolved as a person of interest, but he was not. Let me back up. So the case investigators very diligently tried to put together a timeline of Chris Melton's actions the day before and the day the terrorist's body was found. And that effort alleviated a lot of suspicion in the minds of the investigators that worked on the case. Collectively, the thought was Chris Melton is not at the top of the person of interest list. The timeline that the case investigators assembled related to his activities had him, and I'm working from memory here, had him at home the night before terrorist's body was found. His parents.
Say at home, where do you mean?
Well,
Yes.
Lack of personal knowledge. Hearsay.
All right. Here's the objection. Mr. Yamashili, any response?
Judge, I think Mr. Griffith has personal information about the timeline that was assembled by the agency. Obviously, the state will be calling witnesses to establish Mr. Melton's whereabouts at the time that this murder occurred. But I do believe that this witness has personal knowledge of the agency's timeline.
I'm going to overrule the objection. You may continue.
So, Mr. Griffith, you were talking about the steps that the agency took in order to establish a timeline. Can you talk a little more about what witnesses or were witnesses interviewed in order to establish that timeline?
Sure. The agency interviewed Chris Melton, Chris Melton's parents, a coworker of Chris Melton's, I believe his name was Josh, and interviewed bank employees related to a banking transaction that occurred the day that terrorist's body was found. And
you said interviewed was the timeline that the agency put together, established that there were individuals who said Mr. Melton was with them during the time that Ms. Baker was murdered?
Based on the collective statements of all of those people, it would have been virtually impossible without some magic technology to move you from here to 60 miles to the west for Chris Melton to have killed Tara Baker.
I don't have any other questions, Judge.
Cross-examination, Mr. Cruz.
Can you let the jury know what year Chris Melton's timeline was finally confirmed?
I would say it was 2000 and, well, I can't say what year it was definitive, not without looking at the supplementals, but it would have been early on in the investigation.
Yeah, sure. And this was based on an interview with Chris Melton. Is that correct?
Right.
Okay. And you just tell me if you agree or disagree. Mr. Melton said he started his morning at his parents' home at 7:15 a.m. You agree, disagree, don't know.
Do we have can I use the copy of the timeline I brought with me?
May I see it? Is that okay? May I see it?
Yeah. Yeah. Sure.
Questions open. me do this. Let's start this way, and I'll get back to Chris Melton.
Okay.
And thank you for allowing me to see this. Can I use this for a second if you need
Sure.
that? I'll bring it to you. And the information in here is all information within your personal knowledge. Is that correct?
That's correct. I just understand that that document was prepared by me more than 20 years ago. So
That's fair. I want to talk about the mitochondrial DNA analysis. Okay. What I understand is on page 5 of 36 of the report, the cold case, FBI cold case form, it states a request has been made to have mitochondrial DNA analysis done on one Caucasian pubic hair, which has not matched any elimination hair submitted. Is that correct?
that's correct.
Okay. Do you know, well, you know that mitochondrial DNA test was completed. Is that correct?
I do.
Okay. And that pubic hair came back to match Mr. Chris Melton. Is that, well, excuse me. I said that wrong. That mitochondrial DNA test came back that it could not exclude Chris Melton as a contributor of the hair.
I don't know that that's accurate. I think my recollection is it matched a roommate. My recollection could be wrong though.
Sure.
There was a lot of hair involved in this.
Sure. Was seeing a copy of the mitochondrial DNA report first your recollection?
Surely, yeah.
Of course, indulgence. Hey, Your Honor, I'll ask this. Some testimony was presented that was not expected. I would like to address the testimony, but it may take me a minute to get the different files together. I would ask if we could take maybe a 5-minute recess for me to collect those files.
We can take a 5-minute recess.
Thank you, Your Honor.
I'll send you on to the jury room. This is a good bathroom break. Please don't discuss the case. Back on the record in 5 minutes.
All right, I'd like to show you. I'm going to mark it defense exhibit 32. And Your Honor, thank you for the 5 minutes.
You're welcome, sir.
Let the record reflect that I've already shown the state was been marked as defense exhibit 32. May I approach you?
Absolutely.
I'd like you to look at, take your time, look over the entire document. The particular page that I'm going to ask you about in regards to response to my prior question is page 4, the first paragraph, and the last sentence in the first paragraph of page 4.
And Your Honor, just to be clear, I understand this is being offered to refresh Mr. Griffith's recollection.
That's correct.
Yeah, okay.
Okay, I got the first paragraph. What was the other part of the last page?
So the fourth paragraph on the last page. I'm sorry. The fourth paragraph on the last page, and I'm saying that wrong. Page 4.
Third paragraph.
Page 4, first paragraph, last sentence.
And Judge, I do believe the witness can just review whatever he would like out of the report that he believes would refresh his recollection.
I mean, I think that is correct. You can
I don't disagree with that, John. I was trying to direct.
Okay.
Have you looked at it?
I have.
Okay. Is your recollection fresh?
It is. So the hair. Yep. So, all right, I'll let you ask.
Yes, sir. So in regards to the hair that was found on this Baker's buttocks, Chris Melton could not be excluded as a source of the hair. Is that correct?
That's correct. And so could not Ashley Hall.
So let me ask you this. We talked about his alibi. Okay. And you mentioned in regards to his alibi that he was with a coworker. Do you recall saying that?
I do.
Okay. Did you obtain any employment contracts to ensure that those two worked together?
I did not.
Okay. Did you go to any place of employment that did you go to any place of employment that they may have worked on January 19th that confirmed that they were coworkers?
I did not. I did not personally interview Mr. Melton or the coworker.
Of course, indulgence, Sean. Were you aware that Mr. McCourty and Chris Melton stayed less than a mile away from each other?
I have a recollection that they lived in close proximity to each other.
Okay. Were you aware that those gentlemen went to high school together?
I don't know that I was aware that they went to high school together.
Were you aware that Were you aware that Josh McCourty drove Chris Melton to Athens?
Yes.
Okay. Were you aware that when Chris Melton gave his alibi to law enforcement, Josh McCourty left the police department?
I don't know that that would have been relevant to any of my analysis.
Okay. The statement that you made is that Chris Melton's alibi has been confirmed. And I want to go through the steps that you all have taken as an agency to confirm his alibi. So as of right now, we've established that you did know that, or you may have known that Josh McCourty stayed less than a mile from Chris Melton, but you did not know that they went to high school together. We agreed on that fact, correct?
No, we don't agree on that fact. I may have known. It's been 20 years. I'm not going to remember all the details. I think I was doing good to pull up the first name Josh from memory, actually.
Yes, sir. But you told the jury on direct examination that you confirmed his coworker. Is that right?
That's my recollection, is that we interviewed his coworker, we interviewed his parents, we interviewed bank employees that were at the bank the morning he visited the bank, and that's how we came to put together the timeline of events surrounding
Yes, sir.
Melton.
And I want to take it piece by piece, step by step, so the jury can understand what was done to verify this timeline. Is that fair?
Sure.
Okay. And please forgive the. I have to grab a couple of different things to go over that with you. So please.
Sure.
Would you agree that during ACCPD's investigation, you all were unable to speak with any supervisor that confirmed Josh and Chris were at Nash Plumbing between the hours of 7 a.m. and 9 a.m. on January 19, 2001?
I can't say. I don't recollect.
And that would be a fact that you were, and I know it's been 20 years. I'm just asking this to put it on the record. Listen, would you agree that fact would be significant?
My recollection of Melton's timeline is essentially this. Josh showed up at his house. They drove to the bank to withdraw some money. They went to a truck, to a company to have some work done on his truck, if I recollect. Those are all the details I can pull from memory off the top of my head.
Sure. So if you don't know, you can just say, I don't know, okay?
Okay.
I think we've already agreed, but I asked just in case. You're unable to speak with any coworkers that confirmed Josh and Chris were at Nash Plumbing between the hours of 7 a.m. and 9 a.m.
I did not speak with any of Mr. Melton's coworkers, other than reading supplementals and putting together the timeline after the fact. I couldn't attest to what was said or not said, or who was interviewed.
Sure. But to your knowledge, you wouldn't disagree that as you sit here at this time, that you don't know if that was done?
I don't know.
Would you agree that you don't know at this time whether or not ACCPD spoke to any receptionists that confirmed Josh and Chris were at Nash Plumbing between the hours of 7 a.m. and 9 a.m. on January 19, 2001?
I don't recollect.
Would you agree that as you sit here today, you don't know if ACCPD was able to speak with any eyewitnesses that confirmed Josh and Chris were at Nash Plumbing between the hours of 7 a.m. and 9 a.m. on January 19, 2001?
Can I have the report that I handed you back?
Absolutely.
Refresh my memory.
Now, I would ask you this. I've read the report. I know there's some language in the report. I would ask that, and just let you know where I'm headed with these questions. I'm going to ask you very specific questions, and if you say that it's confirmed, I'm going to follow up with how. Is that fair?
Sure. Okay.
All right. So I believe the last question I asked you is, as you sit here today, you're unaware as to whether any any eyewitnesses confirmed that Josh and Chris were at Nash Plumbing between the hours of 7 a.m. and 9 a.m. on January 19, 2001.
Here's what I can definitively say about Nash Plumbing. Back in 2006, when I was reviewing the case supplementals and interviews related to this investigation, my note says that Chris Melton and Josh McCurdy visited Nash Plumbing from approximately 7:45 to 9 a.m. on the morning of the 19th. That was based on an interview that Billy Ricketts did on January the 19th, 2001 and January the 21st, 2001. I think the best source of information related to that interview would have to come from Mr. Ricketts or from the people that were the subject of his interview.
Sure. Can you repeat those times to the jury?
Sure. 7:45 a.m. to 9 a.m.
All right. So you were unaware that Josh McCurdy told law enforcement that at 8 a.m. he was in Grayson at a house. Were you aware of that fact?
I can't say that I was or was not. I don't recollect.
Well, you spoke of Detective Ricketts' report. Would you like to see Detective Ricketts' report to refresh your recollection?
Sure.
Court's indulgence. I'd like the record reflect that I am showing, and please forgive me, officer. Good afternoon. My name is Mike Cruz. I represent Mr. Edric Faust. It has been a long day.
David Griffith.
Thank you, Mr. Griffith. Please forgive me. Let the record reflect that I am showing the state Detective Ricketts' report from January 21st, 2001. Let the record reflect that I am showing the witness, Detective Ricketts' report from, I said the date wrong. I need to correct the record. From January 20th, 2001.
Okay. So my notes list Ricketts' report from January the 19th and January the 21st.
I have those two.
Okay.
Now I'll give you all three. I'll give you the 19th, 20th, and 21st.
Okay.
And what I'll do to make it easiest, since we're talking about Josh, I want to start with Josh. Is that fair?
Sure.
Okay. It's okay if I approach you?
Mm-hmm.
All right. Mr. Griffith, I would like for you to read the second paragraph on that document, second paragraph, line number 4.
Okay.
You would agree that Josh McCurdy stated at 8 a.m. he was in Grayson checking a house for leaks. Is that correct?
He said that they went to a house to check leaks.
At what time?
8 a.m.
But you just told this jury that from 7:45 to 9 a.m. they were at Nash Plumbing.
Well, the jury that was this is my recollection of what happened. It's based on these notes here.
Understood.
Right.
Will we agree at this time that there's at least one error in the notes?
So, sir, this is a supplemental report written by a case agent. Hopefully, at the time that we prepared this, we went back and listened to the interviews directly. But I can't recollect what we did 20 years ago. But the case synopsis that we took with us to the FBI in 2006, we collectively made the analytical determination that from 7:45 to 8 a.m., Melton was at Nash Plumbing.
So the time has changed from 7:45 to 9 a.m. to 7:45 to 8 a.m.
From 7:45 to 9 a.m.
Okay, excellent. May I approach?
Sure.
And just to make sure that we're clear on what we established that Josh said that he was in Grayson at 8 a.m. Would you agree with that?
Yes. That's what the supplemental report that I read says.
Okay. And the one that you mentioned that your notes were based off of, is that right?
No. My notes were based off reports from the 19th and the 21st.
Okay, so we'll go to the 19th. Showing the state, Detective Ricketts report from January 19th, 2001. Yes, sir.
And I guess no objection. I think that is Detective Ricketts' report from January 19th of 2001. I don't know that the witness has been asked an additional question that he has said he doesn't recall in order to refresh his recollection with this report, however.
Sure. Sure. Chris Melton stated that they went to Grayson, Georgia after 9:30 a.m. Is that correct?
I don't know that I can say. I don't have a recollection of what Chris Melton said at this point 25 years later. I'm looking at the notes that are here in front of me to try to recollect, but I can't definitively say what Chris Melton said.
Would Detective Ricketts' January 19, 2001 report refresh your recollection?
Possibly.
And I would like you to look at paragraph 2. Sentence 3, the third sentence from the bottom to the bottom of the page. And let the record reflect I'm showing the witness Detective Ricketts' January 19, 2001 report.
Okay.
So Chris stated they were in Grayson at 9:30 a.m. Is that correct?
That's correct.
And just to make it clear for the jury, so Josh McCourty's alibi for him and Chris is at 8 a.m. We're in Grayson. Chris Melton's alibi for himself is at 9:30 a.m. We're in Grayson. Is that correct?
That's what that supplemental report says. Yeah.
Okay. And this was the report you told me you relied upon. Is that correct?
So we referenced the interview that Ricketts had. We probably listened to the interviews.
Officer, we've already talked about this. We've already agreed on this. We talked about this earlier. So you didn't tell me that the January 19, 2001 Ricketts report was the report that you
So we
relied on?
looked at the total collective case file back when we prepared this in 2006, which would have been the interviews. If there were video or audio interviews, we would have reviewed those. We would read those supplemental reports. Our collective assessment was we felt like Chris Melton was nowhere near Athens, Georgia during those hours.
But officer,
Whether it's in Grayson or at Nash Plumbing or it wasn't Fawn Drive in Athens, Georgia.
but you would agree with me, law enforcement officers don't go off feelings, they go off evidence. Is that right?
That's correct. Yeah, but it's not abnormal to take statements from different individuals and have time variations in their statements. It's difficult for people to remember what they did yesterday.
Sure. What if they say they went to different places? Is that abnormal? Is that abnormal?
I don't think they say they went to different places. They collectively agree that they went to Grayson, right, to check a house for leaks.
Sure. So this is what I like to do. I like to show you the January 20th, 2001 report from Detective Ricketts, and I would like you to advise the jury of where Mr. McCourty said they went after leaving Nash Plumbing. Is that fair?
Well, Judge, I'm going to object to that. Refreshing recollection isn't handing Mr. Griffith the report and asking him to relay to the jury what the report says. The question needs to be whether or not the report refreshes and brings to mind independently a recollection of that event. Sure.
Any response, Mr.
I agree.
I'm going to sustain the objection.
Josh McCourty stated after leaving Nash Plumbing that him and Chris went to Chick-fil-A. Would you agree with that statement?
That's what the report said.
So Josh McCourty said they went to Chick-fil-A. Chris Melton said they went to Truck Customs. Would you agree?
I think they did both, probably.
Well, we'll get into that. We're going to get into that. But Chris's next stop was Truck Customs. Is that correct?
Right.
Okay. And Chris says that they were at Truck Customs around 9:30 or sooner.
That's possible. I don't remember, what exactly his statement was.
Sure. Was he in the report? Refresh your recollection?
All I'll be able to tell you is what that report says. So if that report says,
Well, I'm sure I'm moving the ball on me.
but what you need to recognize is that's a summary of an interview that was conducted with this individual, and it's a summary that's paraphrased. So that wouldn't have been the best evidence for us at the time looking at this case file. We would have listened to the interview. Hopefully, I don't recollect if Ricketts recorded it or not, but that was the expectation at the time, is that you would record your interviews. We would have listened to the recorded interview.
So I want to make sure that you and I are on the same page. So it's not Ricketts' reports that you relied upon. It was the recorded interviews that you relied upon.
So we looked at the totality of the case file when I started looking at this case, which included audio recordings, video recordings, supplemental reports that case agents and investigators wrote, the totality of the case file as it was when we picked it up in 2005.
Sure. So I asked you a couple of questions. If you don't remember, we'll play the audio recording for you. Is that fair?
Okay.
And Judge, I am going to object. I think the witness has testified that all this will do is give him an opportunity to say what is in the report or what is in the recording, not develop it independent recollection of his own. I think that was his testimony the last time that a report or anything else was offered to him. So I'm going to object to that. Ted Brickett's I anticipate he's going to testify in this trial. So I'm going to object at this point to using cross-examination as a method to just read in portions of a police report.
May I respond? Of course. The state opened the door to this line of cross-examination. This witness, nowhere in the discovery file, mentioned a statement that we confirmed Chris Melton's. Let me rephrase that. The anticipated testimony for this witness based on the state's discovery file had nothing to do with confirmation of Chris Melton's alibi, or non-confirmation of Chris Melton's alibi. When the state elicited an answer from him stating that we confirmed Chris Melton's alibi, it would be impossible for Chris Melton to be in Athens at the time, and he relied on these reports in making that decision. The state opened the door to this line of cross-examination. That's one, but I think that misses the issue of the state's objection. In regards to the state's objection, Mr. Griffin stated that he relied on these reports as well as recorded audio in coming to his decision, Your Honor.
So let me ask you this question, Mr. Cruz. What is it that you're trying to do right now?
Confront the statement that he made that Chris Melton's alibi was confirmed. It was not, Your Honor. We have evidence to show that.
I'm going to sustain the objection and ask you to move on.
Yes, ma'am. Officer, I have no more questions for you.
Okay. Can you redirect Mr. Yonashvili of this witness?
I just want to clarify, because there were a couple questions that Mr. Cruz asked you that I think the tail end of your answer may have been cut off. Just want to clarify a couple things. Mr. Cruz asked you if Josh McCurdy said.
Objection, Your Honor. You just stated that we did not go down that line of questioning, so I would ask that the same restrictions placed upon the state.
Okay, well, that's not exactly what I said, but what is your specific objection?
Relevant, Your Honor.
Okay. Mr. Yonashvili, how is that relevant?
I'm simply asking the witness to clarify the answers he gave to two questions that Mr. Cruz directly asked him.
All right. Anything further, Mr. Cruz, based on that?
I would just simply ask the same restriction that's placed on us that we can't get into that with this witness. I would ask that the same restrictions placed on the state. As I mentioned, Your Honor, they opened the door to this line of questioning. I was confronting the answer. If I can't ask about it, and I stopped as soon as he made a suggestion on the court stated that I couldn't ask those questions, I would ask the state not to make them. Let me rephrase that. I would ask that the state is the same restriction placed on the state that's placed on the defense.
And if I could respond briefly.
You may, sir.
This is a question that Mr. Cruz did ask and received a response to with no objection. So I don't understand that argument. And I believe it is something that's proper in redirect to ask about specific responses to questions asked on cross-examination and the answers that were admitted in front of the jury.
All right. Yes, sir.
He's trying to skirt around the honorable court's ruling. Your Honor has made it clear that that line of questioning is not appropriate for this witness. If he didn't object to it, he can't open the door, allow the questions, object. The honorable court says, no, those questions are not allowed, and then get up and follow up on the questions that I understand the honorable court is saying are improper for this witness. So I would ask that the state not be allowed to ask those type of questions.
All right. Thank you. All right. So with regard to the actual objection, I think Mr. Cruz, you're misstating what the court did. I have said this before. The use of the word restriction is not appropriate. The court made a ruling based upon the law and the analysis of the objection and what it entailed. It is not actually called a restriction. The state made an objection. The court ruled on it, and I sustained that objection. With regard to this particular moment, the state is asking to redirect based upon two questions that the defense asked that were permissible. I'm going to allow it. You may proceed.
So I want to start first with a question that was asked to you. I think Mr. Cruz asked you a question of Mr. McCurdy said he was in Grayson at 8 a.m., I believe was the question. Your answer said they were. What do you mean by they?
So Josh McCurdy said that that's what the supplemental report said, they. So, I think the best way to, let's back up and talk about what I know. Collectively, at the time, we were reviewing all of the interviews that had taken place previously in this case, where we looked at Josh's statement, Chris's statement, the parent's statement. Collectively, they all put Mr. Melton to the west, way out of Athens, Georgia. There may not have been perfect agreement in the minute-by-minute recollections of where people were, but at the end of the day, there were multiple people that put Chris Melton over at his home, near his parents' home.
Well, and I'm sorry, and I just want to stop you because I think I might have asked my question poorly.
Okay,
but
hang on one second, Mr. Yonashvili. I think Mr. Cruz has an objection before you continue. Go ahead, sir.
The state has opened the door again, and I would ask for the opportunity to cross-examine this witness on the statement that the witness just made for the jury.
You will certainly get the opportunity to cross-examine. I don't know. I'm not going to respond to the opening the door at the moment. I don't know that that's necessarily an objection. But if you need to recross this witness, you certainly may do so. Go ahead, Mr. Yonashvili.
And I'm sorry, I'll ask it more precisely. They is a plural pronoun, correct?
I take that to mean, based on my collective knowledge of the case, that Josh and Chris.
Okay, that was my only question. And I'm sorry, I should have asked it in a more precise manner that way. Mr. Cruz asked you about some mitochondrial DNA results, and he said this result indicated that Chris Melton could not be excluded in the report. And your answer referenced one other person in addition to Chris Melton. Who were the people who could not be excluded as contributors of that here?
One of Tara Baker's roommates and Chris Melton.
Okay.
I believe it was Ashley Hall.
That's it. It's just those two questions.
Recross, Mr. Cruz.
Absolutely, Your Honor. I just want to follow up on the specific question that the state asked you. He asked you what did he stated that on cross-examination. I said he, you said they, and they means Chris and Josh. Is that correct?
That's how I took it.
Okay, that's fair. And then he asked you about the timing of being in Grayson at 8 a.m. Is that fair?
Yes.
So I'm asking you a different question from what I asked you before. Chris Melton stated that he was at Nash Plumbing at 7:45. Is that right?
I believe that's correct. Yeah. So my notes say that, and this is a case summary that was presented to a bunch of investigators at the FBI, right? We believe, based on the totality of the interviews that we listened to, the case supplemental reports that we read, that Chris Melton was not in Athens, Georgia. He was over near Nash Plumbing.
But officer, you already said that you all didn't confirm, or you're not aware of you all confirming Chris being at Nash Plumbing.
That's not what I said. I said I couldn't confirm, but I'm looking at this case file multiple years down the road, looking back at interviews that were done in 2001. As I sit here today, 20 plus years later, I may not recollect accurately what we looked at 20 years ago. But my understanding of the case is we felt collectively at the time that Chris Melton was not, that it would not have been possible for him to have been in Athens, Georgia and killed Tara Baker.
Okay. And that was based on, I think we agreed, just you all's collective feeling. Is that correct?
No, not our collective feeling, our collective review of all the evidence that have been collected to date.
So let's talk about the evidence. You would agree that law enforcement spoke to Chris Melton's parents 4 months after Ms. Baker's death?
I couldn't tell you when they spoke to them. Here, 20 years later, I don't know what day they spoke to his parents.
Mr. Griffin, we can't have it both ways. We can't say we're sure that we confirmed Chris Melton is away from Athens, Georgia, and then we asked about the specific.
I don't think those are my words.
Hold on. I'd ask that Mr. Cruz ask questions to the witness, not make comments about the witness's response.
Yeah, I think that's correct.
Yes.
That's a question, Mr.
Yes, ma'am. But you would agree that, I believe it was, I won't even say the date, but in May of 2001, law enforcement went to interview Chris Melton's parents regarding his alibi for the first time.
I cannot tell you when they went to interview them for the first time. Sitting here today in 2026.
That is fair. Did you look at any report that discussed when they went to interview?
I'm sure I did.
Was seeing that report refresh your recollection?
All I would be able to do is read back the report to you at this point. And I'm not trying to be belligerent or difficult. I can't tell you, what we did 20 years ago to a certain date.
But also, you just told the jury what you all did 20 years ago. We just want to understand the foundation of it. Is that fair?
Again, Judge, Mr. Cruz is to ask the witness questions, not make comments about the witness's responses. So I would object to form the question.
That's correct, Mr. Cruz. Ask the question if you want to.
I do want to, Your Honor.
And go ahead.
Please forgive me. And I'll say, please forgive me, Mr. Griffin. Let's take it step by step, okay? You relied on Detective Rickett's January 19th and January 21st report. Is that fair to say?
Ask and answer.
I'll allow it. Go ahead.
Is that fair to say?
Yes. And the only reason I can say that is because I have it in my notes that's what we relied on.
Okay, excellent. And we've agreed that from 7:30 to 7:45, Chris Melton stated that he was at Nash Plumbing.
My notes say that from 7:45 to 9 a.m., Chris and Josh McCurdy were at Nash Plumbing. And that this is a summary of a lot of interview that took place. So as I sit here today, all I can tell you is we didn't believe they were in Athens, Georgia. Now the best way would be talk to Chris Melton, right? And Josh McCurdy.
I just want to follow up. So let me ask you this. Is it fair to say that we shouldn't, and this is the best way for him, so please forgive me. Based on our conversation here today, your report may not be the best place, your report may not be what we need to trust in determining whether or where Chris Melton was on that day. Is that fair?
We started out talking about what my recollection and understanding of the case file was. And my analytical assessment in 2006, and still to this day, is that Chris Melton was not in Athens, Georgia. And that's based on all the testimony of the people that we've talked about.
And that's Josh McCurdy, correct? Chris Melton, and Chris Melton.
You can say yes or no, please. Sir.
Yes. And bank employees at a bank. I want to say it was Wachovia, but off the top of my head, I can't be certain.
You would agree with me that Chris Melton wasn't at the Wachovia until 9:08 a.m. Is that correct?
I don't know for certain.
But you spoke to 4 people. Is that right?
No, more than 4 people.
Okay, so it's no longer Josh McCurdy, mom and dad, Chris Melton, and bank employees. Who else did you speak with?
My recollection is we spoke to Chris Melton, Josh McCurdy, Chris's mom and dad, and 2 bank employees.
So for the purposes of this conversation, we'll take the bank employees out of it. You and I have agreed upon that you didn't know that Josh and Chris went to school together. Is that right? We agreed on that.
No, we haven't agreed on that. I don't remember if I knew that or not. Right now, as I sit here, I don't recollect.
Did you note it in your report?
Not in the report that's in front of me, no.
Okay. And
I'm not sure why it's relevant. What does that have to do with anything that we're talking about?
Well, we could talk about it after court, but as of right now, the honorable court has said I only ask questions. So can you answer that question for me, officer?
What's that?
The question is it in your report that Josh and Chris went to school together?
No, and I don't believe that I would have included it in my report if I'd known it.
So your report does not include all the details relevant to this case. Is that fair?
I think it includes the key details that were important to our investigation at the time that I prepared it.
But officer, you told the jury that Josh and Chris were employees. Would you agree that that gives a different significance from high school classmates? I'll say that.
Absolutely. The totality of the relationships between all the people involved are for the jury to weigh. Absolutely.
And were you aware that Chris Melton was his parents' only child?
I believe I was.
And is it fair to say, do you have children, officer?
I do, yeah. And parents will do a lot for a child.
I don't even have to ask my next question then, officer. In regards to Nash Plumbing, that's really what I want to focus on. I want to focus on the Nash Plumbing. I want to make sure that we're on the same page. We've gone from, I believe, and correct me, I think I'm going to say this wrong. We've gone from 7, give me the times that you say Chris is at Nash Plumbing.
So on this timeline, we have from 7:45 a.m. to 9 a.m.
at Nash Plumbing. And we've established that Josh McCurdy said at 8 a.m. they were in Grayson, Georgia.
Right.
Okay. And we've also established that Chris Melton said after 9:30 a.m. they were in Grayson, Georgia.
Right.
Okay. So you agree this is one contradiction in the alibi?
And like I said before, there are going to be contradictions when people are trying to recollect minute by minute.
That is fair.
Right.
That is fair. Would you agree that after leaving Nash Plumbing, Chris Melton stated that they went to?
I think it was Truck Customs.
Correct. However, Josh McCurdy stated they went to Chick-fil-A. Is that correct?
That's what the supplemental report has in it. Yeah.
Sure. And this is a question I want to ask you. Okay. You would agree that Josh McCurdy was asked if he went to the bank with Chris Melton. Would you agree with that?
Yes. I feel certain that was a question that was asked of him.
Okay. And Mr. McCurdy said he didn't remember.
I don't recollect what I can't tell you what he said.
Would he in the recording refresh your recollection?
The same objection as before, Your Honor. This witness has indicated repeatedly that all the reports or recording would do would prompt him to say what is in the report or recording because he didn't interview.
Sustained.
Yes, ma'am. Yes, ma'am. Court's indulgence. Chris stated that they went to, well, excuse me. Do you recall Chris stating that they went to Forsyth and met with a contractor named Mike? Do you remember that?
I don't remember those details.
Do you remember anyone at ACCPD ever speaking to a contractor named Mike that could confirm that Chris was in Forsyth?
I can't say with certainty whether or not a contractor in Forsyth was spoken to.
Okay. And I ask you this, and I'll let this probably be my final question. When it comes to the questions I asked you, there's no certainty, but you'd agree when the state asks you if Chris...
Object to that question. It's argumentative.
Sustained.
Is it fair to say we aren't... Outside of the 3 individuals you spoke to, excluding the bank, is it fair to say we don't have any other evidence of where Chris Melton was between 7 a.m. and 9 a.m. on January 19, 2001?
Mr. Cruz, what I can tell you with certainty is that as I sit here today in 2026, my assessment of Chris Melton's timeline in 2001 as an investigative analyst that's investigated hundreds of violent crimes is that Chris Melton has substantial testimony from other people that puts him away from Athens, Georgia at the time Tara Baker was killed. And our assessment in the analytical unit at the Athens Clarke County Police Department was that Chris Melton could not have killed Tara Baker.
That's based on those?
That's based on the totality review of the case file at the time that we looked at it in 2005. And that's what we presented in Quantico, Virginia at the FBI Academy.
Sure. And even the FBI advised you all to investigate Chris Melton's hard drive. Is that correct?
I recollect that there was a suggestion to look at his hard drive in an email from Christine DePoyster. I don't know that Chris Melton had a hard drive to look at.
Well, this is what I follow up with. If ACCPD was so certain that Chris Melton was away from Athens, why would the FBI request or instruct you all to look at his hard drive?
It goes back to something I said before. We did not eliminate Chris Melton as a person of interest. He was not at the top of our list of persons of interest. So, from an analytical standpoint, we had to look at, could we absolutely eliminate him? I would not absolutely eliminate my mother from the crime. If somebody came and said that my mom could possibly have been involved, but it made it, the totality of the statements that we reviewed made it seem very implausible that Chris Melton was in Athens, Georgia at the time Tara Baker was killed. Now, if you presented some significant evidence, if Chris Melton was seen on video in the neighborhood with a timestamp of 8 a.m. on January the 19th in 2001, that might change my assessment. But
can I ask you this?
Sure.
You'd agree that Mr. Faust wasn't seen on video at 8 a.m. in the neighborhood. Is that correct?
I didn't say he was, but I was talking about what might change my mind. Now, if we saw a video of Mr. Faust in the neighborhood, that would be a clue, right?
But you also didn't see any video of Deer Park. Is that right?
I don't think I saw any video from Deer Park.
And outside of the bank, so we're not talking about the bank. We're going to assume that the bank is at 908. Between 7 a.m. and 9 a.m., you all didn't collect any video where Chris Melton was located. Is that correct?
The only video that I recollect being collected, or I don't think it was collected, I think it was seen, was Chris Melton in a bank.
That's fair. And to conclude my questions for you, FBI stated search the hard drive. That wasn't done, was it?
I don't believe there was a hard drive to be searched.
So that's a no?
I cannot say with certainty that we didn't search a hard drive as I sit here today, but I do not have any recollection of searching a hard drive.
Okay. Well, I thank you so much for your time. I thank you so much for answering my questions, Your Honor. Those are my questions for this witness.
Any redirect, Mr. Yalamanchelli?
No, Judge.
May this witness be excused? Mr. Yalamanchelli, may the witness be excused.
Yes,
Any objection from Mr. Cruz?
Did you receive a subpoena from our office?
I did not.
Okay. No objection.
You're free to go, sir.
May I sit in the courtroom, Your Honor?
Yes, you can. Your testimony is over. All right, ladies and gentlemen, it's 5:30. We have gone a little bit past sort of my 5 o'clock stop, and so we are going to stop. Thank you for your patience. I'm going to release you today, ask you to return tomorrow at 9 o'clock. The attorneys in the court are going to take up some things outside your presence, so hopefully we'll be able to start right at 9 o'clock tomorrow. We are going to finish tomorrow. I believe it's at 2:30. Is that the time? Okay, 2:30 tomorrow. And so because of that, we are going to bring lunch to you all again tomorrow. We'll bring you the, I'm not sure what it's going to be. It may be menus again. I'm not really sure, but we will certainly provide that for all of you. Please don't discuss the case, do any research, go on the internet and look up anything you may have heard. Enjoy your evening. We will see you tomorrow at 9 o'clock.
There's genotyping software. Okay. Talk to the court, if you will, a little bit about your educational background.
I have a bachelor's of science degree in forensic chemistry with a concentration in
Okay, I believe this is the Daubert hearing of a lady from California, from a lab out in California. I believe this involves the vaginal swabs that were ultimately mixed up. But we will go through this tomorrow because my kids are about to wake up from their naps, and it's been really peaceful while streaming, so I think I'm going to keep it that way and call it for now, and I will see you all tomorrow. Please like, share, subscribe, do all the YouTube-y things. Don't forget to like and turn on notifications for the fundraiser stream on Friday. And with that being said, I hope everybody has a great day. Bye, everyone.
Tara was 23. When they took her from the world, her body was violated. Her house was set on fire. The wall kept what it saw, and the floor kept all the smoke. They left her.